staff who have been working really hard under an accelerated schedule, I understand. Thanks also to the Green Party for allowing me the opportunity to appear on its behalf. And thank you to the previous submitters who have given their time and energy to speak on the bill this week. The Green Party has made a written submission, which you can take as read. However, I'll be taking the opportunity to add my own thoughts with permission from the party and to speak to some of the submissions that have been made since that initial written submission. Now, greater and more qualified minds than mine have spoken at length on the theory behind this bill. It lays out a set of principles for good lawmaking, and in doing so makes a strong implicit claim about the role of government. Egregiously, obligations to te tiriti o Waitangi are not included in these principles, nor are commitments to the environment, nor the Bill of Rights. As previous submitter Eddie Clark noted, however, the bill makes it clear that you can't legally challenge legislation based on the principles. Champion of the bill, David Seymour, has also been consistent in minimizing the power of the bill, calling criticisms of it alarmist, which begs the question, why has so much time and energy been invested in getting it so far? Looking at the practical aspects or the practical impacts of the bill, I think paints a clearer picture. So Aotearoa is made up of 78 local authorities, right? Each of these authorities can administer bylaws. These are, under the Local Government Act, secondary legislation, and therefore they would be subject to the retrospective application of this bill. Most councils administer a fair number of these. The Deneden City Council reportedly administers 40. This bill would see every council in the country analyse every one of those bylaws for consistency against the new principles. If those bylaws contravene the bill's principles, then they will need to craft a public response justifying those bylaws. Now, Carolyn Canton of the Dunedin City Council, or a lawyer, in-house lawyer for the council, raised an important point, I think, which is that district plans might also fall under this definition. So in addition to an incredible amount of duplicative admin work, we can expect legal battles to address the ambiguity that this bill would create. None of this work is cheap. Now, like many people in this country, I live in a city that faces massive floods with increasing frequency and severity. Our local government is critical in both responding to these and in creating the infrastructure to mitigate them to the extent that we can. Meanwhile, every town in the country will be required to relitigate its liquor bans and its freedom camping rules. Is this really where we should be spending our time and effort? Another practical consideration here is the bill's cost to the taxpayer. Officials have identified a 20 million cost per year for the enhanced bureaucratic process that this bill creates. And notably, this is a minimum cost. Advice from the public sector subsequently suggests that this would likely be higher. So again, a per year cost, estimated 20 years. So it's a minimum $400 million estimated spend. The Ministry of Regulation has thus far been unable to provide an estimate as to the amount of money that it might save. But critically, the costs created here are unequal. If legislation does not comply with the principles, the authorities behind that legislation have an additional task, and that is writing public justification for that legislation. So again, theoretically, this bill does not prevent the creation of new regulations, but in practice, it creates additional barriers for any that prioritize public good, but affect private property. So the explicit purpose of the bill is to reduce the total amount of regulation. The bill itself prohibits legal challenges to new legislation. Therefore, we must conclude that this practical chilling effect on legislation is the bill's intent. It would be tempting to describe the bill as yellow tape, but tape actually has utility in my life. This bill is, it's the political equivalent of microplastic, unnecessary, ubiquitous, and quietly contributing to pollution and death across the motu. The strategy of chilling, though, it's not limited to the application of the bill itself. When I was offered a chance to speak today, I had to be briefed on the risks associated with publicly opposing it, as I'm sure many other speakers have. champion of the bill, David Seymour, has used his considerable platform to single out and ridicule citizens who oppose the bill. In theory, these actions are fair play. Sorry, Marama, I see you have a hand up. Is that for post-speech? Yeah, cool. Cheers. Yeah, sorry. David Seymour's been ridiculing people who oppose the bill, right? In theory, these actions are fair play, or playful even. But the reality is targeted harassment campaigns and like credible threats of violence. For this example, I don't really need to illustrate how this would have a chilling effect on opposition. And I don't think it's a coincidence that this tactic has been used to defend this particular bill. So, in theory, this bill should not pass. From a legal perspective, it's a bad law born of bad practice. From a democratic perspective, it was only supported by 0.22% of submitters in the first round of submissions. And from a historical perspective, it has been shot down 3 times already, albeit in slightly different forms. What happens to the bill in practice is up to the Select Committee and ultimately up to Parliament. So to the MPs supporting this bill, I would ask, is this really what you got into politics for? Will passing this bill genuinely help your constituency? And will you take responsibility for the results of its passing? Because I'm calling in from South Deneden, and when the city floods again, you won't find anybody debating the theory of property rights. You'll find them knee-deep in mud and sewage, helping their neighbours sandbag their yards, and I don't think passing this bill is going to help with that. So on behalf of the Green Party, I recommend that the government abandon this bill and focus on what works to improve the quality of legislation, ending the abuse of urgency and following democratic process and listening to New Zealanders, such as the 88% of submitters who opposed the bill at its first stage consultation.
Okay.
Thank you.
Well, thank you, Mr. Treadwell. We've got a quick question here from Marama Davidson, and we're about 2 minutes of time.
Thank you. Good to see you, Mickey. You just talked about an example of real impact on real property rights challenges. So then, can you think of other examples of how the passage of the Regulatory Standards Bill will potentially negatively impact on the people of Deneden?
Certainly, thanks, Marama. So as I was saying about the retrospective application of this to existing bylaws, right, that draws a lot of council resources. Now, the impact, like immediately on Deneden and on other territorial authorities, is that those resources can't be put to use elsewhere. So either it's going to slow down the capacity of the council to do, actually put into place bylaws, or they will have to hire additional personnel, which will result in rates rises. So we'll see a less effective council or a more expensive council service, which of course is through rate rises, given that we're already in a fiscally constrained situation with our local governments. Thanks for the question.
Okay, I think we'll leave it at that, Mr. Treadwell. Thank you for coming in from South Dunedin this afternoon, and all the very best with the rest of the day.
Kia ora, and thank you, Cameron.
Kia ora. Okay, Danella's our clerk this afternoon, and have we got the NYU Church, Brett Reed in Select Committee Room 4, Danella?
Yes, they're here in person.
Very good. Okay, I'll invite them to the table. Thank you for your patience. Thanks for coming into Parliament. You've got 10 minutes. We're in your hands, but as you can see, if you leave a little bit of time for Q&A, that's appreciated as well.
All right, we'll do our best. Ngā mihi ki te atua nāna nei ngā mea katoa. Tēnā koutou katoa. Greeting to those of you online, to those staffers in the room, and to the guests behind us, some of which come from us and some of which come from across the motu. My name is Reverend Brett Reed, Minister at NYU Church in Wellington, and I'm here with Vicky Mabin, a parishioner today. At Ngaio Union, we seek to live God's love in Ngaio by being a warm and vibrant Christian community where everyone can belong. We play a significant role in creating opportunities for meaningful connection, conversation, community engagement, and civil dialogue for the people of Ngaio and beyond. As a Christian community, we believe that we have a clear duty to love God, love our neighbours, and care for our planet, with a particular emphasis on caring for the oppressed, neglected, and the marginalised, and taking actions to improve their lives. We strongly oppose the bill because fundamentally it threatens both people and planet. In our written submission, we raised multiple serious concerns about the framing of the problem, which we think is flawed from the outset. One of its main justifications has been that low productivity is due to too much regulation, but there are many instances where the reverse is true. For example, the leaky homes debacle, where we needed more regulation, not less. New Zealand's lawmaking and regulation is well regarded internationally, according to various international comparisons. If anything, we need greater transparency and protections against lobbying, which this bill makes worse. What's more, the Ministry for Regulation and many other advisors and experts have advised that the bill is not needed. In our submission, we provided 8 main reasons why we oppose the bill, including issues with the principles.
Kia ora. I'd like to just pick up on 3 of the principles that we would like to discuss. Firstly, the rule of law, Section 8A3, every person is equal before the law. Of course, we agree with this principle. It's in the UN Declaration of Human Rights and the Bill of Rights in various forms, very similar. However, its inclusion in this bill seems odd to us. It doesn't align with the explanation that we've heard from the Minister that no one should receive any special privileges based on race. We're concerned that under this interpretation of equal before the law, people will be stripped of any privileges or preferential treatment that they currently receive if it's seen to be race-based. At the same time, the bill gives more privileges to people who own property. Elevating property rights right now does not do anything to correct well-documented material effects on health and well-being that are still felt by many Maori due to the loss of whenua in the 19th century, and I'm referring to work by Tom and Grimes, 2022. It would instead lead to increasingly greater inequities between the haves and the have-nots, between present-day property owners and those who had their land confiscated years ago. In a fair society, we need equity, not just equality before the law. The second principle I want to address is the takings principle, which has received a lot of coverage, so I'll try to make it brief. We believe that this will make it a lot harder to enact laws that improve public health by limiting the sale of harmful products such as tobacco, alcohol and vapes, or protecting the environment and hence our own health and well-being. It will also hinder laws to address the cost of living crisis. And for instance, Minister Willis is looking at ways to force supermarkets or electricity providers to make real reductions for consumers. But how is she going to do this if fair compensation has to be paid? In the case of electricity, according to Keith Turner, recently retired chairperson of Transpower, meaningful reform of the electricity market in the interests of consumers would likely reduce share market capitalisation of electricity generators by billions of dollars. And how on earth are we going to pay that without raising the cost of living? Because in fact, it all comes back to us if the government has to pay. Of course, the minister can propose a bill, or proposing a bill can declare no takings, but setting the expectation of compensation provides an anchoring effect. And there have been many instances where governments, i.e. taxpayers, have ended up paying for remediating environmental damage left behind by mining companies, chemical companies, forestry companies, and so on. And the takings principle would normalise other people picking up the tab for companies' messes. These are bizarre and perverse outcomes of this takings principle, which would likely be unacceptable to most New Zealanders, yet in the bill in its current form promotes them via the takings principle. And the third one I want to touch on is good lawmaking. Clause 8, Section 8, Clause I. Consulting will be to the extent reasonably practicable and the agency decides which persons are directly and materially affected. We have big concerns here. How will person be defined? Any definition needs to give sufficient regard to ordinary folk, to communities, to collectives, the marginalised, to tangata whenua, to future generations, and to those who may be subjected to downstream effects, e.g. from pollution. But these people may not be viewed by the agency as being directly and materially affected, even if they are, and this is our concern. An overarching issue throughout the principles is that the interpretation of value-laden terms like fair, due, reasonable is not defined yet. We're awaiting guidance in Section 27 once the bill is enacted. With so much power vested in one minister, his self-appointed board, who he says will be economists, and they will provide such direction, and this situation is very, very open to lobbying from big business, we fear that all these terms, and hence the decisions, will be biased towards corporates and away from people and planet. As a result, the persons considered to be affected and needing to be consulted will be too narrowly defined, and consultation will be too rushed or avoided altogether, which is allowed for in the bill. This doesn't sound like good lawmaking, but it's actually what we've seen recently under, for instance, the pay equity legislation that was changed without any consultation of those directly and materially affected. So our question to the Select Committee and to Parliament is, how would pay equity and other legislation rushed through under urgency recently, how would that be consulted on in the RSB?
More broadly, we're very concerned that if this bill is enacted, it will become harder for those ministers who want to enact good laws that protect the public or the environment or improve our well-being, as these ministers will have to argue why their bill is non-compliant, making for a lot more work to do what is in the public interest. It will become easier to give in to these principles than fight them, leading to a normalisation of principles that are libertarian, let's be honest, despite the adverse effects on New Zealand society. Many actions favoured or approved under this regime will degrade the environment, biodiversity, and worsen climate-related effects. And for the record, we do not agree with the omission of Te Tiriti o Waitangi, as we view it as essential to good lawmaking in Aotearoa, New Zealand. To conclude, while the bill sounds like an innocuous measure to remove red tape, it is quite clear that its true purpose is to strip power from ordinary people to benefit corporates and individual property rights, leaving a trail of environmental problems for generations to come. Quite honestly, it is a wolf in sheep's clothing. It does not put New Zealand first. It is not needed, and there are better options. We strongly oppose it, and we implore you to show that you care for New Zealanders and for the planet, and vote down the bill at its second reading. Ngā mihi, thank you.
Okay, thank you. You're at time, but I'm going to give Dr. Duncan Webb a quick question.
Good. Thank you, Mr. Chair, and thank you for that submission. You're not the first faith-based organisation to submit on this bill, and I want to ask a slightly different question. That is, if bringing that to this discussion and kind of the interface between politics and faith, what are the principles or values or touchstones that you think should be driving good legislation?
I think the tiriti is a good place to start, to be honest, with kotahitanga and manaakitanga. I think that would weave it in very nicely. I think we need to be consulting with everybody. We need to be acknowledging and valuing people and our planet. We're here as kaitiaki, we don't own the planet. Sorry, I jumped in.
No, that's what I was going to say. That covenantal basis of Te Tiriti is, from a faith perspective, something that grounds us in our care for people and whenua. So, yep, that would be my answer too.
And from a professional thing, I'd say there are lots of ways you could streamline the processes and make them better. And yes.
Okay. Oh, well, thank you for coming in to both of you, the NYU Union Church. We appreciate you taking the time and coming into Parliament this afternoon.
Thank you very much.
Thank you. Okay. Ms. Clark, where does that leave us now?
So we've got the next submitter online.
Okay. Ngā Waihui o Pairangi.
Kia ora.
Kia ora. Welcome. Thank you for your patience. You've got 10 minutes. We'd possibly like to have some dialogue with you at the end, so please leave us a little bit of room, and we look forward to your 10 minutes. Thank you.
Tēnā koe te hea mana o tēnā ki ngā mema o tēnei komiti, tēnā rākou te katoa, e mihi ake ana kia tātou e whakakotahi nei tēnei rā. Hoa no, ko Ngāti Rangi tēnei, ko ngā iwi maha o te kāhui maunga tēnei, e mihi atu ana kia koutou katoa, nā rungi ngā tini āhuatanga o te wā. Ka tangi hea tonu te ngā mate, e rā mate ki rungi a tāua e meno, o tino ngā mate huhua o te wā, ka tangi hea ka mihi a rātou, hoki mai kia tātou pēnei ana, tēnā koutou katoa. My name is Elijah Pue. I'm a trustee of Ngāti Rangi's post-settlement governance entity Te Tōtara Hoi o Pairangi Trust and Ngā Waihua o Pairangi Trust. Ngāti Rangi is an iwi nestled in the southern foothills of Mount Ruapehu, and our rohe broadly encompasses the southern Ruapehu area, including Ohakune Wauru Raitahi. Our submission is a powerful testament to the values and concerns of Ngāti Rangi, and it's my privilege to share its essence with you today. We want to be clear that Ngāti Rangi strongly opposes the Regulatory Standards Bill in its entirety. The bill is an extreme piece of legislation that does not aim to improve the national regulatory system, but rather entrenches existing power structures. We call for its complete rejection and emphasise that the bill overlooks Te Tiriti of Waitangi, as a number of other submitters have said, a core founding document of Aotearoa, New Zealand. This bill promotes individualism and private property rights while undermining collective Māori values and responsibilities such as tino rangatiratanga, mana motuhake and kaitiakitanga. It claims to improve the quality of regulation and introduce principles of good lawmaking, but in reality it overrides the existing principles of accepted law. Lawmaking in a democratic system should be non-partisan and not subject to capture by the interests of a minority party. This bill, however, redefines what good regulation looks like through a narrow political ideology with vested interests in who that law serves. Here at home in Ruapehu, we have several examples that demonstrate the current regulatory environment in Aotearoa has served democratic principles, enabling participation in equitable society. However, the regulatory standards bills will weaken these principles. For instance, in small towns around Aotearoa, supermarket monopolies keep prices high through land covenants, forcing remote and rural communities to pay higher prices than the national average for goods. Breaking these covenants to facilitate a public good would require extensive compensation under the proposed bill. In Ohakune, we have a serious challenge in developing papakainga housing due to the prioritisation of Airbnb and short-term rental markets over those that call this place home. We're focused on reconnecting wānau to our ancestral lands and developing papakainga as part of our broader strategy. However, this bill will further exacerbate the problem that we have in this rohe, prioritising those that don't call this place home over those that do, both for Māori and all New Zealanders. This bill will have a significant impact on the volcanic hazard monitoring and planning, which is important for Ngāti Rangi and iwi like ours nestled under the foothills of Mount Ruapehu, an active volcano. In the 95-96 eruptions, collaborative partnerships were built to improve volcanic monitoring, warning systems and civil defence protocols, and indeed you would have seen over the last few days those have simply kicked in due to the earthquakes that we've been experiencing here. The Regulatory Standards Bill, however, motivated by investment for profit, threatens to compromise these essential safeguards on the safety of our community. The recent closure of the Winstone pulp mill, both pulp mill and sawmill, is another example of how the reluctance to manage price volatility has allowed dominant energy providers to prioritise profits over affordability and regional equity. The human cost of this closure is still being felt across our region. The bill will have major constitutional impacts on our nation. The Waitangi Tribunal has already recommended that the Crown immediately halt the advancement of this bill, as the consultation process was fundamentally flawed and violated treaty principles of partnership and active protection. The tribunal found that the absence of meaningful engagement with Māori on the political impacts, or the potential impacts of the legislation, has caused stress, uncertainty, resulting in further prejudice. The bill will erode legal protection for vulnerable humans, future humans, human values, and the environment. It claims to serve the rule of law, but true legal equality must entail and encompass economic and political equality, which this bill fails to address. We provide several recommendations in our submission to make the legal system fairer to those with economic hardship, such as reinstating public funding for Section 27 cultural reports in the Sentencing Act, increasing legal aid provisions, and raising the minimum wage to a living wage. This is a duplicitous piece of legislation which promotes phrases such as equality under the law, liberty, and transparency in a thin attempt to disguise its true agenda. Our present regulatory systems have been honed through discussion, scholarship, deliberation, and good Crown Māori relations and negotiations over hundreds of years. They're based on Te Tiriti o Waitangi, a founding law of partnership with tangata whenua, which is being disrespected and disregarded by this approach. Our current regulatory systems have also been influenced by other laws, ensuring basic protections such as the UK Bill of Rights, enacted as the Bill of Rights Act. Advocates supporting rights for Māori, workers, women, animals, disabled persons, and environmental protection have risked liberty to ensure that we have equitable laws and structures that we take for granted. The regulatory impact statement confirms that Aotearoa has a high reputation for efficient and effective lawmaking compared with similar countries. This bill would replace 100 years of efforts and scholarship with a simplistic set of rules that do nothing but further entrench power and privilege. We argue that not only is the bill unusual, but the process to truncate the usual process of consultation is further unusual. Ngāti Rangi has a 1,000-year vision for prosperous people in a prosperous environment and a prosperous community for everyone that calls this place home, Māori and all New Zealanders. This bill does nothing to contribute to our intention that Ngāti Rangi will continue to vibrantly exist in 1,000 years and beyond. We therefore call for the complete rejection of the Regulatory Standards Bill and ask that those of you who are in leadership positions across Aotearoa and indeed in Parliament itself have a real think about what impact this is going to have on the cultural fabric of this very place that we call home, because continuing with legislation like this, like the Treaty Principles Bill, further pushes us apart unnecessarily and continues to divide and will eventually conquer us into becoming something that our ancestors never ever intended us to be. Tēnā koutou katoa.
Thank you very much. I've got a question here from Maramino Kapakingi.
Thank you, Mr. Chair. Tēnā koe, Elijah. Hoino, just I roti wā whakaaro. So in your submission, you've noted the tribunals finding this bill would constitute a breach, specifically the principles of partnership and active protection.
Yeah.
So in your view, what would you say to why are these principles found in New Zealand jurisprudence confusing to supporters and proponents of the bill?
In my opinion, I would say the reason that people find it confusing is because they believe that the places like the Waitangi Tribunal only exist to support one particular race in this country. The Waitangi Tribunal wasn't just set up to indeed be a vehicle for claims for Māori to be heard. Things that go against or breaches of the Treaty of Waitangi don't just have an impact on Māori, they have an impact on everyone. And so I think in answer to your question, the naysayers of this kaupapa don't want to listen to the tribunal because they believe that they are only existing for the betterment of Māori whānau and communities. And actually, I think the scholarship that exists on the Waitangi Tribunal and the legal minds around that table can provide actually a great service for everyone who calls Aotearoa home, Māori or not.
Ka pai, tēnā koe.
Okay, thank you. Thank you very much. Thank you for joining us this afternoon. We appreciate that. And all the very best for the rest of the day. Thank you for submitting to the committee.
Kia ora.
Kia ora. Okay, that brings us to just 1 minute past 1. And the New Zealand initiative. Madam Clerk, have we got them online or in the select committee room?
They're in the select committee room 4.
Oh, very good. Okay, we've got Dr. Eric Crampton and Dr. Bryce Wilkinson. We welcome you both. Pretty familiar surrounds to you both. You've got 10 minutes if we can. Members I know will be keen to engage, and so if we can leave as much time for Q&A as possible, then please do.
Thank you so much. I'll make some very brief high-level comments as introduction and then pass over to Dr. Wilkinson, who has been lead on this submission. I think that the high-level purpose of this kind of regulation has been missed in the past few weeks of debate around it. When Parliament wishes to achieve some beneficial public purpose, it often has a choice of how to do that. Sometimes it makes the most sense for government to spend money to achieve a beneficial public purpose in ways that provide net benefits. Other times it makes most sense to regulate to achieve that same beneficial public purpose and provide net benefits to New Zealanders. When it spends, it faces two constraints. It faces the set of legislative constraints and procedural constraints through the Public Finance Act, but at least as importantly, it faces the contest between different competing budget bids in the budget process. Money spent on one initiative can't be spent on another. It's more difficult for governments to achieve a purpose by spending money than by regulating in cases where that cost is borne by the private sector or the community otherwise. The bill here tries to get this back into a kind of balance, both by having greater scrutiny and more process around regulation for assessing its consistencies with long-standing principles of regulation, but also by thinking about the principle of compensation, because if a beneficial public purpose is being provided, the cost of that shouldn't just fall on those who are compelled to provide it. It should fall on the beneficiaries of it, which could be the public more generally, or a defined set of beneficiaries. The bill does not require that compensation, but it requires a bit of thinking about it. I also like that the bill goes a little bit further than current regulatory impact assessment, where Parliament has had a tendency to use urgency to get legislation through on a crowded legislative agenda. RISs are often inadequate. The Regulatory Standards Board here would have opportunity to weigh in after legislation is passed to give an assessment of the regulation and its benefits. So that would add to greater scrutiny. Again, Parliament can do what it likes, but it would help with transparency for people to see the effects. I'll shut up and turn over to Bryce.
Okay, I'll be short, Mr. Chairman, because I want to maximise the time for questions. The submission supports the bill subject to 9 recommendations. Some of those relate to the importance of supporting arrangements and quality implementations. It makes 3 specific suggestions for changes to the bill, and the body of the submission addresses a number of concerns expressed by others. And Chapter 4 gives attention to the Legislation Design and Advisory Committee's response to the bill. So thank you very much. I welcome questions.
Okay, thank you very much, gentlemen. I'm going to go straight to Dr. Duncan Webb.
Kia ora, thank you for that. Look, my first question is a relatively straightforward one, I hope. I'm looking at your submission on paragraph 7 on page 10, and you have an implementation pathway. The strange thing is all the things you want, including a regulatory standards board, could be done without any legislation whatsoever. So it seems very strange that we've got this very heavy-handed approach where all we need is a political will and a cabinet that wants to do it, to in fact implement all the things that is set out in this bill. So why on earth do we need a piece of legislation on the statute book?
Well, we need a piece of legislation on the statute book because outcomes are unsatisfactory for New Zealanders in a very broad sort of way. The housing affordability problem is one, but the low productivity growth rate is another. And these principles are of fundamental importance to a functioning democracy.
Yes, I've got all that. I understand your arguments there, even if I don't agree with all of them. But that can be done simply by administrative and executive action. We don't need, and the first rule of legislation is don't create it if you don't need it.
Well, I'm sure you're aware that at the moment there's an enormous number of procedures which Cabinet sets, regulatory impact statement procedures, other procedures like Cabinet Official Circular 2021 Part 2, which sets out Cabinet's expectations and requires officials to identify any departures from 148 default principles in the legislative guidelines. And it requires a minister taking something to Cabinet or to a Cabinet committee to give reasons for departures. So those things aren't working well enough. And this committee is already looking at, one inquiry is into greater accountability of the public service to Parliament. This proposal is very similar. It's just to make executive government give Parliament more information about the nature of things it's wanting Parliament to pass. So it's a transparency mechanism for better informing Parliament, and it's needed because things aren't working well enough with all the existing processes.
Look, I know you're a fan of the theory of economic regulation and the idea that there's a sort of a market for regulation, including a market for bad regulation and bad laws. Isn't this just an example of, in fact, just that there's some interest groups out there that would love to see this value set put into our statute book, whereas, in fact, it's just another layer of bureaucracy that favours one group of people over another?
No, it's very serious, and it's very driven, contrary to all the assertions about improper measures. It's very driven by, I'm an economist, by the economic problems this country is facing. Things are unsatisfactory all over the place. Education, sort of housing, health sector availability, ability to use land. Look at the problems with these decrepit buildings deteriorating because people can't afford to meet them up to earthquake standards, but can't demolish them either.
There are
problems.
Last question, Dr. Webb, because I've got three others behind you. Duncan, you got one more if you want one.
Okay. No, look, I'll wait, because Dr. Wilkins is going to submit again in his own capacity.
Okay, shortly, thank you. Thanks, Dr. Webb. I'm going to go to Francisco Hernandez.
Thank you, Chair. I just have a clarifying question, and please correct me if I misheard your submission, but did you say that you were supporting the Regulatory Standards Bill subject to your amendments being accepted, your proposals? So does that mean that if it wasn't accepted, that you wouldn't be in support of it anymore? Just to clarify.
No, we're not saying we're not supporting it anymore if they aren't done.
Okay, right, yeah.
Yeah, we'd like to see those amendments, thanks.
Thank you.
Okay, I'm going to go to Dr. Deborah Russell.
Oh, I've withdrawn mine, but I would like to ask Dr. Wilkinson a question in his next appearance.
Okay, no problem, Deborah. Mrs. Karpakini, Maramino.
Thank you, Mr. Chair. Kia ora, Dr. Wilkinson. Thank you for your submission. Look, so the Supreme Court of Aotearoa has already told us that, noted that tikanga is the first law of the land. So in your view, should English common law be allowed to evolve in and of its own right, despite having no connection to pre-existing authority that emanates from this land, from this whenua? Be interested to hear your thoughts on that, Dr. Wilkinson. Thank you.
Yeah, certainly. No, our courts, obviously, sorry, I don't mean to be offensive, but our courts will modify and evolve common law in the New Zealand direction, particularly now there isn't recourse to appeal to the Privy Council.
And that's despite the fact that the Supreme Court has already clarified, stated, noted that tikanga is the first law of the land.
That's what it's done. That's a fact.
So Dr. Wilkinson, so do you agree that most peoples in most democracies in the world are not all English, and that no single democracy in the world are the same? So, but reflect the land and society those democracies are founded on.
Yes, definitely. I quote Confucius in one of my submissions.
I might jump in with just another observation. It's fun to think about what would have happened had something like the Regulatory Standards Bill been in effect when iwi lost the right to regulate their own housing on their own land. That was very clearly a taking that ought to have been considered.
Yeah, well, fun. I don't know whether it hasn't been fun. What, you know, here we are.
I agree.
And in fact, actually, oh, yeah, and of course, you agree with it. We experience it. So to that end, actually, if I might just, Mr. Chair, there was one little comment I picked up, I think, from the gentleman that just spoke. You opened up by saying it seems like you're hearing that things might have been missed in these last few weeks about this bill and maybe some misinterpretation. So I'm interested your view then on the last 3 attempts at this bill coming through. What happened in the last 3 then? Did they miss the same things the last time this was chucked out? Interested in your thoughts. Thank you.
Bryce is more across the history of this than I am.
The very first occasion, the Select Committee considered it and thought it wouldn't proceed, but more work should be done. That led to the 2009 Regulatory Task Force report. And that report, with the lawyers making a very big contribution, recommended a remedy along the line of the Bill of Rights Act remedy of appeal to a court for a declaration of inconsistency. And that was strongly opposed by Auckland University lawyers and Jeffrey Palmer's and others. The next version involved a public referendum in the support, but also continued the recourse for a declaration of inconsistency from the courts. With the current version, no one was in support of that anymore, such as the view in Wellington about the unpredictability of the courts. And that led to the replacement of that remedy by an appeal to a board. And there are lots of conversations which could be had about the structure and nature of that board, whether it's a parliamentary body, all sorts of things. So that's shortly the evolution of it. Yeah.
Okay, I'm going to go to Dan Bidwar, and then Dr. Wilkinson will have your submission on its own. Dan Bidwar.
Thanks, Mr. Chair. Thanks, Eric and Bryce, for your submission and recommendations. I just want to give you the opportunity to maybe respond to some of the specific objections that we've had in the Select Committee. We've heard, various objections around this bill, relegating to treaty. It's undemocratic. It disregards other principles. It makes things more bureaucratic. I just wanted to see if you were able to speak to some of those specific objections and your observations on whether they are valid or whether your counter objections to those.
Okay. Yeah, it comes to my submission on that. The appendix to that addresses 47 questions, which are really criticisms of the bill, and gives the answers to them. So that's my biggest contribution to trying to help the committee find its way through these enormous differences of opinion about what the bill is about.
Yeah, and just for my part, before I cede to Bryce's solo submission, it hasn't been particularly helpful that a lot of public commentary has viewed the constraints in here as being binding on Parliament. Some of the reporting requirements are binding, but none of the compensation requirements are binding. They're simply advisory. Parliament can do as it likes, as it can in spending measures. So I think that has made public discussion of the bill a lot less fruitful than it otherwise ought to have been.
Okay, we'll leave the New Zealand Initiative a submission there. We've had 14 minutes already. I know members want a little bit of extra time for dialogue. So, Dr. Wilkinson, if you can give some brief comments, and then we'll allow a few minutes for more exchange. Thank you.
Yes, thanks, Mr. Chairman, and I will be brief because I do want to maximise questions time. The thrust of my personal submission is, firstly, why regulatory equality is really important for community well-being. It's not an ideological thing. And that's the real motivation for my support for this bill. And the fundamental common law principles is where it draws on most heavily, and they are enumerated from the legislative guidelines. It's not something we've made up, deeply embedded in Anglo-Saxon law. And that big appendix is my biggest contribution to the committee. It's a labour of love, 42 responses to questions. But since making that submission, Mr. Chairman, I've prepared another note which really compares the principles with those which are required by that Cabinet Office circular I mentioned earlier. And if you like, if it's useful to you, I could table that for the committee's consideration. It also addresses the question of the costs, and are they really going to be as large as the Ministry of Regulations suggested? That's all. Thank you very much.
Okay, no, I'm sure everyone's happy to receive that additional information. I'm going to go to Dr. Duncan Webb.
Thank you, Mr. Chair. Look, I've read your submissions and other material that you've written on this, and it does strike me that there's something of a communication breakdown, because this framework, which you've had a lot to do with, is in a sense an economic theory, isn't it? It's a theory that prosperity is based on unfettered exchange, voluntary exchange of private property. Would that be a fair observation?
No, absolutely not. It's the rule of law. What government does is absolutely crucial to prosperity, for better or for worse. The principle of this bill is Parliament can pass anything it likes. It is the sovereign lawmaker. There's nothing in this bill which stops it from passing anything it likes. It's really important. It's absolutely essential that governments do things well. National defence, the courts, police, public law.
Throughout your submission, you say voluntary exchange is the cornerstone of prosperity. They're roughly your words in a number of spots. And I guess that's what I'm latching onto.
No, there's nothing in there at all which says that public goods aren't important. To the contrary, it says that Parliament is the collective which represents the public good. Parliamentary sovereignty is maintained, so the collective dominates. All it's saying is what's in the legislative guidelines, that when government acts, it should do so in a principled way. Well, who could argue with that? So then the question is, what are the good principles? That's where the legislation guidelines come in. That's what they've been about.
Okay. So, but your principles look to, various things, rule of law, non-retrospectivity, private property and takings, but they leave out Indigenous people's rights, disabled people's rights, human rights, environmental biodiversity, and all of these other values, which in other systems outside, and I'm not saying economics isn't important, but outside of kind of a fiscal economics, considered to be central touchstones for good legislation. I'm just really perplexed as to why your principles are kind of so impoverished of all of those other values, which everyone here has been talking about.
No, well, with respect, that's totally wrong. They're all there. What it's doing is taking the fundamental principles out of the legislative guidelines. So rule of law, dignity of the individual, security of the individual in their persons, they can't get assaulted, smashed up, and in their possessions. Those are pretty fundamental to the good society.
What about
all this is doing is making sure executive government reports to Parliament on those fundamentals.
But why is the right of Indigenous peoples to express their culture and for government to protect that not part of your framework?
It doesn't exclude it. Tell me this.
No,
tell me this.
Deprioritises
what protection for Maori is not in there in the existing principles that has been missed? Okay. That's what I want to know.
The protection of traditional waiata, which might be in your framework a property right, but if you look at how those kinds of things have been addressed previously, they've been addressed in entirely different ways.
Well, there's absolutely nothing here which stops that, but the common law always does this.
But it doesn't stop it, but it deprioritises it. It makes it a second order rule.
Okay, I'll let Dr. Wilkinson respond, and then we're going to go to Dr. Deborah Russell. I'm just conscious we've got to be fair to everyone else that's queued up this afternoon. Dr. Wilkinson, if you can respond to Dr. Webb, and then we're going to go to Dr. Russell, and then we're going to have to leave it.
Okay, the priorities are done in the legislative guidelines. Chapter 4 does the fundamental principles.
Okay, Dr. Russell.
Thank you, Bryce, for your presentation today and for your thinking. Look, I've been following this debate very, very closely too, and I listened to you on Morning Report the other day, and I'm going to paraphrase, but you more or less said that the opposition to the bill was that there was a lot of groupthink going on. People are telling themselves stuff that's not quite true, inventing false motives and giving the bill sort of false motives for the bill of an unsavoury kind, and then they misrepresent the bill. That's a summary of what you said, not your exact words. I do have them written down. Do you still stand by that?
Yeah, what people are first doing is attacking the motives behind the bill, and they're saying it purports to be just transparency and it purports to be concerned about productivity and stuff, but in fact, it's out to prioritise corporates over everything else. It's out to put an alien philosophy into the thing. So that's the very first thing people are telling each other, that this is ill motivated, and it's not true. You know, I've been an economist in public policy committee working long hours ever since 1970. That is not the motivation, but people will not accept that this is about trying to see New Zealand a better place and about the well-being for all New Zealanders, as cost-benefit assessments are aimed to be benefits for all New Zealanders. So and then the second thing is, no one I know who's opposing the bill is admitting, well, that might be a bit of exaggeration, maybe the LDAC, but people are not recognising it preserves parliamentary sovereignty. They're thinking it stops Parliament from passing laws or it makes it harder. It doesn't.
So, in fact, we've had a lot of legal analysis who says that it will lead Parliament. That's the way these things write. In effect, what I'm hearing is that you're saying that people like Professor Andrew Geddes, Simpson Grierson, Professor Dean Knight, Sir Geoffrey Palmer, the iwi Chairs Forum, the New Zealand College of Public Health Medicine, Environment Southland, the Parliamentary Commissioner for the Environment, the Royal Australasian College of Physicians, John Canton, the New Zealand Law Society, Professor Jonathan Boston, the New Zealand Council for Civil Liberties, the Northern Regional Council, the McGuinness Institute, the Legislation Design and Advisory Committee. All these eminent thinkers, people who are well-versed in public law and well-versed in government, you're saying that they're all wrong and that you're right.
Okay, final comment, Dr. Wilkinson.
Well, name one of those which doesn't attack the motives. Now, I can name one. The Legislative Advisory Committee doesn't.
None of them attack the motives. They attack what the actual effect of the law is going to be. And it's just extraordinary that you would think that these people do not have valid concerns about this bill. These are eminent thinkers and people who've been honoured for their thinking, as I know you have too. But when there is so much opposition to this bill, it would behove you and the others who support it to give some really serious consideration to those views.
Okay, let's leave it at that, unless you've got some concluding remarks, Dr. Wilkinson.
No, I'm good. Thank you very, very much for the opportunity to present and to answer the questions.
Okay, no, thank you, and thank you both, Dr. Crampton as well. Okay, members, we gave that as good a shake as we could as far as time goes. We had 23 minutes. We've got Annette Sykes in the room, and I'd invite her forward with any colleagues and thank her for her patience. Annette Sykes and co, and invite you to for your 10-minute submission, and hopefully a little bit of time for interaction too. Welcome.
Kia ora te whare, kia ora koutou I tai mai ki te whakatina na tēnei kaupapa hohonu. Ka huri au ki te rao ngā reo. With the committee's permission, I'd ask my friend Ms. Tahira of our offices to start our submission, and then I will take us through. And I do want to leave some time to respond, because I think that we have a juxtaposition of opinion and an opportunity to explore that with the New Zealand Initiative and Mr. Wilkinson's submission, I think, quite at odds with the Māori world's view, not just our firm's view, about the discriminatory effect of what has been proposed, both to tikanga Māori rights and interests and resources, and I think a narrowing of the property rights dimension, which would actually prevent compensation to Māori rights in water, for example, I think contrary not only to the principles of Te Tiriti o Waitangi, but also to the principles of a fair and justice fairness and justice, which are the underpinnings of the rule of law.
Tēnā rā koutou katoa mo te tokoiti pia kāre I te mōhio ia Annette me ana mahi o te rā tō mātou umanga ture, he umanga ture kaupapa Māori mātou e kawe nei I ngā tikanga a kuima a koroma e mātou ana ki ngā ture Pākehā e mahi ana I te mahi hei paenga mō ngā whānau ngā hapu me ngā iwi maha o Aotearoa. Mātua rā kua mātou mahi he kōkiri I ngā take kia whakaua I te tika me te pono, kia rewa ki ai te mana o te hake, kia toi tū ai te tiriti o Waitangi. Koe nei tā mātou tāpaitanga e whakahe mārika ana ki tēnei piraurawa atu, e kia nei te Regulatory Standards Bill. So we're a Māori law firm who specialise in advocacy for Māori in both kāwanatanga and rangatiratanga spheres. We operate in both the Pākehā legal system as qualified legal practitioners and in the Māori justice system as practitioners of tikanga. We provide a range of ture and tikanga related services on matters related to constitutional and public law, whenua Māori or Māori land law and criminal defence. And we oppose this bill in its entirety and implore the select committee to recommend it be abandoned at the next reading. I was going to give a bit of an overview of our submission, but I think the volume of submissions in opposition to this bill that have already been presented to the select committee we would be repeating. But just to highlight some of the key points from our submission, we think that it should not be lost on anybody that this is the fourth attempt to have this bill passed into law. It's the bill that just won't die. It's the most rejected, refiled, resurrected from the dead bill in the history of our country. And we think that we should be asking ourselves, at what point does this become an abusive process and procedural harassment? We echo all of the submissions that have said that this bill ushers in the corporatisation of our country and enables a neoliberal takeover of Aotearoa. And it is rooted in an ideology that promotes profits over people, money over manaakitanga, individual property rights over any other, and undermines the government's ability to safeguard collective and public interests. I am now going to hand it over to Annette because I think she wants to say some things in response or in light of the submissions that we've just heard.
Can I also, though, just draw, I have an uncomfortability of the way the submissions process has proceeded this week. I've just watched the New Zealand Initiative and Mr. Wilkinson be given significant time. And I was appalled earlier this week to see Sir Geoffrey Palmer given a very limited time and actually cut off. A statesman of that stature, an individual who's devoted his life to ensuring that the pillars of the legal justice system are reflective of the community values, deserved more than that, as did a number of, I think, prominent individuals and organisations that have been highlighted by one of the select committee members already. I hope that we're not going to give the right wing a sense of priority over the, I think, the grim norm of our nation, who actually stand together shoulder to shoulder in this. People who are have devoted their lives to ensuring that the constitutional fabric of this nation is actually one that knits our communities, provides access to justice, but also enables a development framework for the inculcation of values that ensure our ongoing longevity as partners, as promised in Te Tiriti. I was part of the Waitangi Tribunal. I've heard some significant submissions. I was appalled also earlier this week to see that one of my colleagues has been so threatened by individuals that she had to bring security guards to actually make a submission to this House of Parliament. I hope that there is some censure to individuals if that has been promoted through their media exercise of scaremongering and trying to intimidate or actually prevent the Māori voice from being heard. I also saw this week an enormous outpouring of love for Te Tiriti o Waitangi and the invisibility of this in this bill, which actually means a significant amount for our firm. We've devoted 5 decades to ensuring that the truth of Te Tiriti o Waitangi guides the justice of this land and is not made irrelevant, which unfortunately this bill continues to do. One of the deepest insults is that the bill promises protection of property rights for individuals and corporations that has been denied to Māori for 185 years. Kawanatanga, through the ACT Party, supported by National and New Zealand First, is promising primacy of property rights, requirement for consent and just compensation for the rich of today. However, they do not want to look behind today to go back to a restitution or compensatory outcome for Māori who've been denied the protection of their rights and interests in water. There is no suggestion this should apply retrospectively to Māori. Instead, the bill deliberately eviscerates Te Treaty yet again. Its goal, in effect, is a new wave of colonisation to look in the property rights created over our whenua, moana, mātauranga and whakapapa. When we have demanded recognition of rangatiratanga, requirements for consent and just compensation, we have been met by war, by jail, by poverty and the denial of our sovereignty, and now by threats of violence because we dare to speak out. The protection on offer is so vague and open-ended, it could apply to anything and an individual or corporation. And let's be really, really clear. Māori are not just an individual or corporation. We have obligations as kaitiaki to this land and to all future generations that share this land with us. That is one thing as a child of a Māori and Pākehā relationship that is inculcated in my mind and my soul. There is no definition of property, the limits and its scope of application, no standards of impairment. Vagueness breeds uncertainty, risk aversion by officials, and opportunities for complaints and demands for review of new laws and regulations by any potentially aggrieved property owners. We have argued this before the tribunal on behalf of Ngā Toki Whakarururanga as an interested party in proceedings there. Ngā Toki Whakarururanga is a Māori collective born out of the Y2522 Waitangi Tribunal into the Trans-Pacific Partnership Agreement, a free trade agreement, and they are among the many denied a voice by the committee on this bill. They highlighted the parallels between the regulatory takings principle in the bill and protections for property rights owners under international trade and investment agreements, and the risk that breaching those principles could fuel claims for hundreds of millions of billions of dollars by foreign investors in offshore tribunals through what is known as investor states disputes, or ISDS. The threat or fear of such action could have a chilling effect of making of decisions, especially to implement Te Treaty obligations. Our claimants also provided Official Information Act documents, and I heard Professor Jane Kelsey speak with such passion about how she was denied and stonewalled about even answers to those questions relating to the bill, that shows the contempt that the Deputy Prime Minister, His Honourable David Seymour, has for Te Treaty o Waitangi, which Professor Jane Kelsey has also detailed in her submissions, and she's just one of many. I actually admire the Jane Kelseys and the Anne Salmons of the world, Pākehā allies who have devoted their academic and intellectual careers to ensuring that there is an understanding of these deep fundamental problems that must be addressed if we are to maintain the constitutional sense of united being as a nation that is so fundamental to our future as it is to our past.
Oh, Ms. Sykes, we're just at time, and I've got a couple of questioners here that I'd like
one
to
paragraph, and then off
please.
Is that
yeah, so I'm just saying, wind up with some concluding remarks, and then we'll go to questions.
Thank you for that. When his own officials recommended that the approach to a Te Treaty principle could be developed in collaboration with iwi Māori, Mr. Seymour, apparently, it's virtually illegible if you actually look at the documents. Nowhere in this report is examined how a treaty principle would better deliver regulation for New Zealanders. And I want to actually end echoing the comments of one of the first speakers this week, Ani Makaire. Can I please talk to the statesmen and women of the National Party, of the New Zealand First Party? The power at this moment of time is in your hands to stop this. We urge you to look deep in your hearts and listen to all of the nation, not just a very small section of the nation, and take every effort to put a halt to this, I think, a travesty of justice that has been promoted by people who have not the support of our nation. Kia ora.
Okay, kia ora. I'm going to go to Ms. Kapakini. Maramino.
Tēnā koe, Mr. Chair. E tēnā kaurua Annette, kanui te mihi kia koe, tautoko marika o au whakaaro, o kaha ki tēnei kaupapa, tēnā roho ki koe. Annette, I roti tō mea tō kōrero o tō submission, you talk specifically about setting a dangerous precedent for further governments to rewrite legal history. So can you just talk a little bit more to that?
I use the example
in our, in events, even in our.
Yeah, I use the example of property rights. Property rights is at the heart of capitalism, which is really at the core values that are being promoted by the proponents of this bill. But property rights are being narrowed from the conception, as I understanding, of the conception of it in Anglo-Saxon law, but certainly even in Māori terms as the property rights that are actively protected by Article 2 of the treaty. The fact that there is no compensation likelihood to go back to 1840 is a rewrite, I think, of fundamental precepts of property law. That is really dangerous. The putting in hands of this board the responsibility to intervene, a constitutional intervention, a mechanism that takes the power from democracy to the power that are appointed by those at whim from the executive, is absolutely undermining principles of ordinary democracy upon which this parliament has worked. Those are just two of the examples we highlight. So I'm not actually just talking about Te Tiriti, I'm actually talking about how what is being proposed is undermining the rule of law, undermining the constitutional fabric, and undermining the sense of unity that Te Tiriti promised for this nation.
Okay, thank you. We're over time, but I'm going to give Ricardo Menendez-March a question.
Thank you so much for your great submission. I wanted to ask, who do you think stands to benefit the most when it comes to this bill?
I don't want to say this in pejorative fashion, but rich white men. So, and unfortunately, nowadays there might be some women in the group, but, that's not what we thought about. Our country is born on the belief that we care for the less privileged, that we believe that we share our resources for mutual well-being, that when we hear about housing initiatives, we trust the state with the great ideas of Savage and Fraser to build the ethic of providing a shelter, a home. That's deeply rooted in Article 2 of Te Tiriti, the tino rangatiratanga of our kāinga. The privileged will take, and those that are the ordinary citizens of our society, which are the glue to our society, will be denied.
Okay, thank you. Thank you very much. Thank you, Ms. Sykes, for your presentation and your colleague. And I've tried to be as generous as I can, and we appreciate your fullness and forthrightness this afternoon.
Kia ora, thank you, Mr. Pua.
Thank you.
Well done.
Okay, Madam Clerk, are we with the Human Rights Commission?
Yes, they're online.
Okay, let's have a look. Let's get them up. And kia ora. We've got Gail and we've got Dale. Okay, thanks for your patience. We're just running a little bit over, but we've had a couple of key submitters that people were keen to engage with, and so I wanted that opportunity. But we look forward to your 10 minutes and welcome.
Kia ora, and thank you for the time today. I'll start. I'm Professor Gail Pacheco. I'm the Equal Employment Opportunities Commissioner at the New Zealand Human Rights Commission, Te Kahui Tika Tangata. And with me today, I have Dale Taketimu, our Indigenous Rights Governance Partner. To start with, the Commission's accredited as an A status national human rights institution. This gives us privileges to speak at the United Nations on our human rights matters that affect New Zealand. And our job is to monitor New Zealand human rights and the human rights dimensions of Te Tiriti as part of our nation's human rights framework. I'll take our submission as read and use our time today to speak to the key points we want to reiterate. So first, I'd like to begin with the Commission's overarching position. Everyone in New Zealand deserves to live with dignity, and this means upholding the entire range of human rights that are recognized internationally. From decent housing and safe workplaces to clean water, healthy ecosystems, as well as honouring Te Tiriti o Waitangi as the foundation that affirms everyone's place here. And this bill tries to steer us away from that future. It seeks changes to our lawmaking process that place individual liberty and private property rights on a pedestal, while sidelining Te Tiriti and a broader range of civil, political, cultural, economic, and social rights, which are crucial to our collective well-being. I want to point out that the Commission agrees that we should and can aim for high-quality regulation as a tool to achieve outcomes in the economic, social, and environmental space. However, for a number of reasons outlined in our submission, the Commission opposes the Regulatory Standards Bill. And we're clearly not alone in opposing this bill. The vast majority of submitters have opposed the bill, and it's noteworthy from my point of view that it's drawn criticism from Treasury, the Legislative Design Advisory Committee, constitutional experts, and even the Ministry for Regulation. And the Waitangi Tribunal has also found it breaches Te Tiriti. I will now pass to my colleague Dale to speak to a couple of the key reasons outlined in our submission.
Kia ora tātou. I understand there's an issue with my camera receiving the video feed, but I will present verbally to the Select Committee at this time. Over a few of our key points. First being that the bill introduces lawmaking principles that are constitutional in effect, but misaligned with New Zealand's founding document, Te Tiriti o Waitangi. In proposing principles to guide lawmaking, this bill singles out only a narrow set of rights centred on individual liberty and private property to be considered. Meanwhile, the rights affirmed under Te Tiriti o Waitangi are left out entirely. By elevating a narrow subset of rights while excluding others, the bill creates an unbalanced approach to lawmaking in New Zealand, one that undermines Te Tiriti, the very foundation that gives legitimacy to our law and affirms belonging for all people in Aotearoa. These concerns are heightened by the already limited constitutional protection for Te Tiriti o Waitangi, something international human rights bodies have repeatedly urged the government to strengthen. Furthermore, consultation on this bill has been rushed and inadequate despite its significant constitutional impact. We expand on this in our written submission, including the UN's definition of laws that are of constitutional nature, and in the opposition to this bill presented in the Waitangi Tribunal findings. Second major point of our submission is that prioritising private interests. The Cabinet paper and Ministry of Justice advice claim that this bill is consistent with the New Zealand Bill of Rights Act and New Zealand's human rights commitments. As New Zealand's human rights institution, the Commission respectfully disagrees. The bill ignores the full range of civil, political, economic, cultural and social rights that are recognised under the Bill of Rights Act and international commitments. Instead, it places individual liberty and private property rights above all others. This selective approach to human rights goes against a core principle of human rights law, that there is no hierarchy of human rights. All rights are interdependent and must be treated on the same footing. In practice, this bill risks locking in a lawmaking process where the rights of everyone in Aotearoa come second to private interests, especially those of large corporations with the resources to challenge laws that don't suit them. We are concerned it will have a chilling effect, discouraging Parliament from passing laws that promote the wider public good for fear of legal challenges or new accountability hurdles that unjustifiably block policies for collective well-being and displace the Crown's treaty and human rights obligations. I'll hand back now to my colleague, Professor Pachenko, for our concluding remarks.
So in conclusion, as our submission indicates, we do not believe that the bill will resolve the issue it claims to address. While the Commission acknowledges the importance of regulatory quality and transparency, the rationale for the bill is unconvincing and the bill is unlikely to achieve its stated aims. Failing to ensure that the government's international human rights commitments are respected domestically impacts New Zealand's reputation on the world stage. In November in Geneva, New Zealand reports on the UN Convention on the Elimination of All Forms of Racial Discrimination, CERD, and amongst the list of queries by the CERD Committee for the government was the potential impact of the Regulatory Standards Bill with regard to Indigenous people's rights. Finally, let me end with one of our recommendations from our submission. The Commission recommends a robust process to improve New Zealand's regulatory management system, ensuring compliance with Te Tiriti and human rights standards. As part of this process, we recommend undertaking a thorough analysis of the key regulatory issues and identifying all possible options for addressing it, including non-legislative options and the costs and benefits of those. And throughout that consultation, we think there should be consultation with tangata whenua, and that should be embedded at all stages. Very lastly, I know I'm nearly out of time, and we would like to emphasize that the Commission is here to support the government on legislation with significant human rights implications. If we're engaged early, then the Commission is very happy to help ensure that the laws and policies are consistent with human rights standards. And I thank you for your time.
Thank you so much. We've got one question here from Mariamino Kapakingi.
Thank you, Mr. Chair. Tēnā koutua e Dale, kia ora rā, Gail, tēnā koutua. Hoino, I roti tō, in your submission, Gail, you highlighted the dangers of political principles trying to underpin a process that should be apolitical. Why, can you just talk a little bit more, why is that important for upholding democracy and human rights in Aotearoa?
I'll give that a go first, Gail, if you don't mind.
I think relatively quickly if possible. Thank you.
Yeah, I think what we're trying to present in more depth in our written submission is that there are already a range of commitments the Crown have in relation to human rights and good lawmaking in this country, those most notably being contained in Te Tiriti o Waitangi, which of course is a fetter on Crown power to some extent in the way that that sits constitutionally within our legal framework. And additionally, New Zealand has international human rights obligations that already provide, again, a filter and a fetter for good lawmaking that prioritises the full ambit of human rights, both individual and collective, that New Zealand should be making laws consistently with.
Okay, let's leave it at that. We're just over time, but thank you so much for both of you appearing from the HRC today. We appreciate your work and the time you've taken. Thank you. Okay, I did see queued up that we have NZEI online. Did we have a Rebecca Lessels?
Kia ora.
Kia ora.
Kia ora.
There we go. We've got the full picture now. You've got 10 minutes. As you see, what works is when there's a little bit of exchange at the end. So allow us that if you can, and we look forward to your presentation.
Kia ora. I'll hand over to Steph to start, please.
Thank you.
Kia ora koutou. I'm here representing NZEI Te Riu Roa as the National Secretary, Korimako Tangiata, together with Dr. Shannon Walsh, our strategic researcher. Rebecca, would you like to introduce yourself now, and then we'll go into the submission?
Kia ora rā koutou, ko Rebecca Lascelles tōku ingoa. Ko hau te manukuro o NZEI Te Riu Roa i tēnei tau. He tūmua kia hau kai te teho nā kura a kai te riu o Kawerau I Waiariki. So tēnā koutou katoa. So I'm Rebecca. I'm the current president of NZEI Te Riu Roa. I'm also, in my other job, the principal of an area school in the Eastern Bay of Plenty. Kia ora rā.
So just to remind you, we are a professional organisation and union representing nearly 50,000 members employed as teachers, leaders and support staff in early childhood education and primary schooling, including kohanga reo, kura kaupapa, Māori kura, iwi and whare kura. We've been around for approximately 140 plus years, and the union sees itself as one of the key guardians of the public education system. We will also represent, as I said, support staff through into secondary school and learning support staff employed by the Ministry of Education. So we have a very 360-degree vision of the education system. Our members are part of a value-led, Te Tiriti-based organisation that has a long history of playing a positive role in the education sector and on wider social issues affecting our members and the tamariki and whānau they serve. To be clear, NZEI Te Riu Roa opposes the Regulatory Standards Bill and recommends it be abandoned in its entirety. We echo other submitters who have called on the National and New Zealand First MPs to reflect that although their coalition agreement requires them to progress this bill, we do not think it should progress beyond Select Committee and should go no further than today. We support many of the insightful submissions that have been heard this week, in particular those made by our colleagues at E2, the Council of Trade Unions, PPTTI, Te Wehenga Roa and the PSA. Like many other submitters, we're concerned with the bill's anti-democratic nature, its flawed conception of liberty, its constitutional implications, its implications for the environment, its potential to open the door to privatisation, the concentration of power it invests in a single minister, the poor process used to introduce the bill, including being rushed under urgency in a truncated Select Committee process, and the abhorrent behaviour of Deputy Prime Minister David Seymour in making personal attacks on people who have publicly criticised the bill, to name just a few issues. We feel these concerns have been well canvassed in oral submissions this week, so we thought today we'd focus on some of the specific aspects of the bill and its potential from an education perspective. So I'm just going to hand over to Repika to talk about the first ones of these.
It's our firm belief, or the belief of NZEI Te Riu Roa, that under the Treaty of Waitangi, we have an obligation to operationalise an education system that recognises and uplifts Ākura Māori and their identity. We note that the Regulatory Standards Bill does not recognise the Treaty of Waitangi. We further note that the interim report of the Waitangi Tribunal that considers the Crown's decision to advance this bill without good faith consultation with Māori is a breach of the Treaty of Waitangi principle of partnership. We're appalled at this bill's intentional undermining of the treaty. Our view is that the treaty offers the promise and the blueprint of a way of working that is unique to Aotearoa. We consider the treaty to be the taonga and critical to the success of our education system. We tautoko the submissions made by Kura Kaupapa Māori o Ngā Mokopuna earlier this week and echo the risks that outline concern concerning the impact this bill could have on the protection and flourishing of te reo Māori me o na tikanga. As we will be telling the Education and Workforce Select Committee tomorrow, when we present on the Education and Training Amendment Bill, a bill which seeks to downgrade the place of the treaty and the obligation of school boards, putting the treaty at the heart of education benefits all learners. Kia ora, Steph.
So like many other submitters, we're concerned about the principles in Section 8 of the bill being too narrow, largely reflective of libertarian ideologies and failing to balance collective and environmental rights against the rights of individuals and corporations. We ask, why are not the rights of children, or the requirement to consider the public good, or intergenerational equity, or the precautionary principle, not core principles of this law? This is important, given how far-reaching the bill could be, because if we consider through the lens of education policy, it requires retroactive review of nearly all legislation and secondary legislation, which in education means everything from health and safety requirements to curriculum. We're concerned that the bill's emphasis on a narrow cost-benefit framework could severely chill policy advice that aims to improve educational experiences and outcomes for ākonga. Education policy is concerned with largely immeasurable, but nevertheless critical aspects of education, such as learner well-being or cultural representation and belonging, may be viewed as not being aligned with the principles of responsible regulation. With such policies, it is considerably difficult to quantify the benefits they may have, while at the same time often easy to quantify the costs. Cost-benefit analysis is simply too narrow a lens for assessing the complexity of education policy. So the bill also appears to be premised on the simplistic notion that regulation is undesirable by default. To the contrary, our view is that regulations generally exist for good reason, and this is particularly true in education, where they are often in place to protect and benefit children. For example, performing regular sleep checks might appear to be a burden on the time of early childhood educators, but changing these could result in the avoidable death of children in care. Paying ECE teachers pay parity might be seen as a unnecessary regulatory burden, but it is critical to quality teaching and learning, the oral language of young learners, and the social development of our children. We have seen in the case of the ECE regulation review recently that was driven by Minister Seymour, that there have been some quite concerning erosions of health and safety, for example, across the current legislation. So if that is a model of the future behaviour of government under the Regulatory Standards Bill, we fear for the safety and the quality of our children's education. The one-sided view of regulation embedded in this bill is dangerous and shows a disregard for previous experiences of the harmful results of deregulation, such as the Pike River mine disaster. We are supportive of good regulatory practice, but regulatory changes need to be considered on their individual merit and on the potential impacts they may have, quite apart from ideological assumptions about the desirability of regulation as such. Finally, we urge you to carefully consider Sir Geoffrey Palmer's warning around sections 41 to 47 of the bill, which concern the information gathering powers of the Ministry for Regulation, in particular section 47, which makes us enforceable in court. We think it's important to point out to the committee that schools are Crown entities, so these sections apply to them, all 2,500 of them. We have strong concerns that this puts the privacy of children in schools at risk and could lead to litigation against school boards who attempt to protect this privacy. We suggest that members of the committee, in particular those from National and New Zealand First, consider how comfortable they are with the Ministry for Regulation having the power to order a school to supply information about children, for example. Government has used urgency and not even met the basic requirements of regulatory impact statement documents and many of its laws passed under urgently recently. It would be ironic if this goes through and, you know, when so much legislation has passed in the last couple of years, but then requires a significant increase in bureaucracy and cost by having the Regulatory Standards Board and officials then go through a second time to review it. We believe strongly that this bill needs to be rejected. So thank you for hearing our submission, and we're happy to take any questions in the time left.
Okay, thank you. We are pretty much at time. I can't see any hands here go up, so I presume that you've done a fulsome job on your submission and made yourself loud and clear without anyone needing additional clarity. So thank you so much for appearing before the committee this afternoon. We appreciate your time and energy.
Thank you very much.
Thank you. Okay. Clark, does that lead us to the environment Southland, Mr. Marcus Roy? Or is it Nicole Horrell? Nicole Horrell.
Hi, yes. Kia ora, I'm Nicole Horrell, Chairman of Environment Southland.
Nice to see you. Thank you. You've got 10 minutes at Environment Southland, no doubt coming from Invercargill today. Very good. So please proceed and allow us time for questions at the end.
Kia ora, I'm Nicole Horrell, Chairman of Environment Southland. I'm a sixth-term councillor holding the chairman's seat since 2016. I'm joined by Philip Moore, who is legal counsel for Environment Southland. Environment Southland appreciates the opportunity to speak to the Finance and Expenditure Committee on the Regulatory Standards Bill. Environment Southland strongly opposes the bill in its present form. While we acknowledge and support Parliament's role in scrutinising legislation, we believe the bill creates significant risks and outweighs any benefits. We advocate instead for strengthened existing tools to improve legislative quality without introducing unnecessary complexity. A core concern of ours is the bill's elevated private property rights over other fundamental rights. Another major concern of ours of this bill is it is actually silent on the Treaty of Waitangi, New Zealand's founding constitutional document. Omitting the treaty from the regulatory process sends the wrong signal. In Southland, Ngāi Tahu has legislative rights and customary rights outlined within the Ngāi Tahu Claims Settlements Act, which ensure they are a partner and a participant in the regulatory process with the Crown and local government. The process to develop the principles of the bill has not been undertaken in partnership with iwi, which in our view is actually a breach of the treaty. We consider the bill a bill aimed at improving lawmaking must reflect New Zealand's constitutional and cultural realities. The treaty must be explicitly included in the principles guiding legislation. Environment Southland is concerned that the bill gives the ministry sweeping powers to demand information from councils with no clear limits or scope or time frame. This risks operational burden and costs on local authorities and could actually disrupt critical services. Strong safeguards are needed to ensure information requests are reasonable, targeted and manageable. In its present form, the bill appears to restrict the ability of all governance, from cabinet ministers to local government leaders, to react to issues with flexibility and agility. And I guess my question is, will this bill strengthen democracy or restrict it? I'll now hand over to Phil Moore, our legal counsel.
Unfortunately, Phil was unable to join on the live stream today, but effectively I'll read Phil's part from Wynne Williams. So it's Environment Southland's view that enacting this bill in its current form entails significant risks that outweigh any potential benefit. The bill introduces tension between private property rights and matters of public interest. Private property rights are not, and never have been, absolute. The Southland community has repeatedly told council that the right to use a property for a particular use needs to be weighed against effects of the community's right to a healthy environment. On its face, the bill would apply to regional plans because regional plans are secondary legislation. This means that rules in a regional plan that impair property rights would trigger the compensation provisions in the bill. By way of example, is the introduction of a rule in a regional plan restricting or prohibiting the establishment of plantation forestry in water-short catchments as an example of property rights. Would the property owner need to be compensated for that impairment? What if particular high-intensity types of farming activities were restricted to maintain drinking water quality for the public? Would the council need to provide compensation for that? And if so, through what mechanism? Extra rates? Who values the impairment? The bill itself is unnecessary. There are already layers of constitutional and legislative protection that drive the making of good quality legislation and regulations. For example, Part 4 of the Legislation Act 2019, which has not yet been used. The Legislation Design and Oversight Committee and Cabinet Office and the Bill of Rights. In conclusion, out of the 6 principles, 3 focus heavily on individual freedoms and property rights, ignoring other fundamental rights like environmental protection, treaty obligations, and rights under the Bill of Rights Act. Such an imbalanced framework risks future legislation being skewed towards individual interests over community well-being and environmental protection. Discussions about fundamental rights deserve broader national debate, being decided through and not decided through a single regulatory bill. And at this stage, we'd be prepared to answer any questions.
Okay, thank you, gentlemen. Loud and clear. I'm going to go to Deborah Russell, Dr. Deborah Russell.
Well, thank you for your submission. It's really good to hear from regional councils about the possible impact of this bill. One of the things that the very small number of supporters of this bill have said again and again is that it's going to provide reports only, that it's just a report to Parliament, and that's so there would there would actually be no requirement to pay for impairment or so on. But others have said it's going to have, force people in that direction anyway. So does the fact that people are saying that it's not going to have actually any impact beyond a report give you any reassurance as to the difficulties for regional councils?
Probably not, especially when you combine it with the rhetoric around the changes to the RMA, which is also very property focused and is also making the same sort of compensation rights of individuals, and I guess who pays. We believe it. Well, property rights obviously is interesting. There are other issues too. I mean, land use, the cumulative effects of doing things. If we can't take that into consideration, it will impact on society going forward.
Okay, thank you.
Okay, any other questions, members? I think we're all good. I will leave it at that, gentlemen. Thank you, Chairman Horrell and the Environment Southland team for your submission, and we appreciate the time you've taken and for engaging in this legislative process.
Thank you for the opportunity.
Thank you. All the best.
Okay.
Okay. Madam Clerk, who have we got up next? Are we ready to go with Matu Macadmia Limited?
Climate Aotearoa online.
Oh, we've got parents for Climate Aotearoa?
Yes.
Okay, let's go to them online. Welcome. Thank you for tuning in. Whereabouts are you coming from today? Oh, can we hear you? We're just having, I don't know if anyone else is having this problem. We're just having a
Can you hear me?
Yeah, we can hear. We can hear you, Olivia.
Olivia. So I'm Olivia down in the Tasman district, but I think Alicia's up first. So hopefully she'll check in. I'm going to come in second.
Alicia, we're just having trouble with some sound. Can we hear you, Alicia?
What about now?
Yep, you're away. Let's go for it.
Awesome. Tēnā koutou katoa. I'm Alicia from Parents for Climate Aotearoa, and with me is Dr. Olivia Hyatt. So diving right in, as you were able to read from our written submission, we oppose this bill in its entirety. We concluded with our reasoning that this bill is has potential to significantly impact Te Tiriti o Waitangi and environmental regulations. We also respect the ongoing tension between economic development and environmental protection is deserving of a broader national conversation to find a balance that respects and safeguards both, especially in the context of our response to a rapidly changing climate. We've also listened to many submitters this week, and we completely support the tangata whenua and tangata tiriti academics, legal and policy experts, researchers, iwi hapu, and the lived experiences and perspectives of various communities. And today we bring a parent perspective. So this bill claims to make all New Zealanders equal before the law, but does this include children and future generations? Other acts, such as the Public Finance Act, have provisions to take into account future generations in their decision-making, common sense, long-term thinking. So how a parent has evolved over the past few decades, largely based on ongoing education, research, and evidence, and we hope and expect that our democracy would do the same. In the past 18 months have been filled with endless submissions of rinse and repeat repeals of legislation and policies that could have easily been tweaked and improved to make fit for purpose, instead of wasting more millions of dollars, like throwing the baby out with the bathwater, so to speak, only to then ironically spend more millions on a ministry and propose legislation that is not fit for purpose, divisive, and very much not clear or transparent, imposing legislation that has already failed to pass 3 times because it's not wanted or needed. And we are struggling with really real problems like a worsening cost of living crisis, rising unemployment, people losing their jobs and struggling to find work, and I'll put my hand up there. And it causes serious financial stress for many families who need to make choices they shouldn't be faced with. And there's also climate change impacts already from increasing severe weather events that Olivia will speak to shortly. This bill also looks to be further entrenching a class system and deepening inequities by prioritising rights of the few over our collective responsibilities. And yes, Parliament is a place to contest and debate ideas, systems and laws, and what is best for our country. And we all have to live and work together alongside each other, regardless of our positions, and collectively face our shared problems, such as climate change, including mitigation and adaptation. And having fringe ideology inflicted upon us in this way is morally corrupt and unethical. And to quote one of our members, the bill is a playbook for fringe beliefs and climate deniers to benefit those that are already wealthy. We want to see more cross-party support for enduring legislation over short-term laws that are going to be repealed by future governments. The RMA is an example of needed legislation that had cross-party support and also needed to be tweaked and improved from the get-go to be fit for purpose today, rather than the big clunky mess it is now. And we can't see how imposing even further top-down clunky legislation like the Regulatory Standards Bill is going to improve anything. We should not be making current legislation even more difficult for future generations who will already be grappling with even bigger and nastier problems than the ones we have now. So before I hand over to Olivia, I'd like to leave you with food for thought. Other parties in Parliament have pledged to repeal this legislation if it is passed. Again, millions of our taxpayer dollars gone to waste. So what if a future government forms a coalition of opposition parties with the promise that a minor party will be able to introduce and pass unwanted legislation based on unpopular ideology that infringes upon the rights and livelihoods of others, one where the vast majority across the political spectrum opposes it, one that creates further division over enduring good legislation? Is that still acceptable? So as parents raising members of the future generations, we ask you all to do the right thing for them. So over to you, Olivia.
Kia ora. I've just stirred up some paradise ducks, so hopefully you can hear me over them. Today I'm coming from my family farm in Upper Moutere in the Tasman district. As Alicia said, we do need better lawmaking. However, this bill is another example of how Parliament is out of touch with the realities on the ground. Yet again, my region is cleaning up after another climate-enhanced weather event. We've got families who've lost homes and much more. I have been recently on my farm and our forests, checking streams and culverts and fences and some of our trees on our family farm and forests. We've got lots of digger work ahead, though we have got off lightly compared to some of our neighbours. This bill does not help my community and other farms and forests and the council clean up or prepare for the next one. It doesn't help us, any of us here on the ground, navigate legislation and regulations now. The number one problem that myself and many around me have with our current legislation is it takes so bloody long to work out what you have to do in the first place. This government is also proposing to get rid of one of the few pieces of legislation in recent times to try and help us navigate that legislation and regulation, and that's the Plain Language Act. I'm frustrated that the response of this government to the well-known and long-standing problems we have with our lawmaking is to add another layer of bureaucracy over the top. Ironically, this bill fails the first test in that no one can understand it or agree on what it will or won't do or how much teeth it will have. This government's done a poor job of explaining in plain language what it does and doesn't do. What my community and all communities across Aotearoa need is legislation that is clear to us, not just for you politicians who have staff to explain it to them. Legislation that is also not changing constantly, that we and our councils can keep up with. Here in my community, like many, there is lots of worry and uncertainty, and the decisions you make have a big impact. For example, advancing private property rights isn't going to fix the catchment problems that have been laid bare yet again in the latest big flood. These wicked problems require our community to work together with our councils and other agencies and government. It requires good data, communication, listening, and compromise. We all have to do our part. I'm very concerned that this bill will just add more barriers and money and time wasted. As soon as the shit hits the fan, We need help, a collective response. We depend on each other in these times. In a catchment, what one landowner or manager does has up and downstream consequences on the farms around them, infrastructure, and the communities. Addressing these hard problems is hard work, and I and many around me are sick of simplistic either-or solutions and top-down solutions and promises to tackle deep structural issues, and in the end you just tinker, or you have bills like this that are ideologically driven. We oppose this bill. Please get on with fixing the real issues with our lawmaking and work with the opposition to make enduring changes for now and future generations. Thank you.
Okay, thanks, Ms. Hyatt and Ms. Hall. That's time. All the best in the Tasman area, Olivia, with the recovery on your farm and in your forest and all your neighbours as well. We're all thinking of you guys down there. Thank you for making the time and making your point so clear this afternoon. Okay. Madam Clerk, are we going to Dr. Barber and Carwina Jones? Who have we got queued up? Okay. Okay, let's bring them through if possible. Okay. They're coming through, I presume. Are we going back to Matu Macadmia Limited? Oh, we're just having a few technical issues here. We're changing computers by the... Are you there, Danella?
Kia ora, kia ora.
Oh, kia ora. Okay. Very good. Okay. We're sorry we missed you a bit earlier, but you're here now. We look forward to your 10-minute submission. Let's get into it. Thank you.
Tēnā koutou katoa. Firstly, the people whom I'm representing has a strong opposition to David Seymour's Regularity Standards Bill. Tēnā koutou ngā mema o te Select Committee, nā kainune ki te whiu i o mātou whakahe I tēnei pire kore takera wātu. This submission is proposed and prepared by myself, He Mana Waka, with my tribal affiliations are Tūhoe, Ngāti Pūkeko, Te Arawa and Tainui. I am a retired veteran of 20 years in the New Zealand Army, 30 years in Māori broadcasting through iwi Radio, TVNZ, Māori TV, Rangi Aotearoa, Sky Sports, Radio New Zealand News and Current Affairs. Also, all my programs was 100% in Te Reo. And now 15 years of voluntary services for the betterment of Māori economic development in Aotearoa. I te kore he ki tēnā, without a vision, ka ngaro te tangata, our people will perish. My submission is on behalf of Matu Macadmia Limited, consisting of 16 Māori land trusts around the Eastern Bay of Plenty. Secondly, as the president of the Memorial Club called Te Hokowhitu Atu ki Te Teko, and I'm also a veterans researcher on Māori health status. I am also very attached to honouring the Treaty of Waitangi. Briefly, I whakapapa tu Aotearoa and Ngāti Pūkeko. Te Arawa, Ngāti Whakaue, Tūwharetoa, me Rangitihi, and Tainui Nai Tai. I would like to start off firstly with tikana. This bill's introduction is littered with typical Pākehā regulations and does not include tikana Māori as a part of this law. It is applied through the lens of a Western and European as one person who uses his position and limits our status as a Māori. This bill wipes out our rights because the way it is written ignores centuries of our customs, tikana, whakapapa, reo, apu, marae, whanaunatana, and kaichakitana. Our tonga is based around our genealogy, customs and cultural values, consultation, and not written rules and regulations on paper that diminishes the status of us as Māori. This legal jargon shows our tikana is eradicated in this legislation and assessments reducing our mana and blocks our Māori legal rights solely within the systems practiced on our marae with whānau hapu and iwi recognition. The mythology of this bill contradicts the Te Riu Waitangi and the declaration of our rights as Indigenous peoples where Māori rights to customary law are paramount. Regulatory standards imposed over our customary authority is my next subject. This bill has created a framework whereby all regulations is justified by narrow vision principles. The restrictions imposed disregard our Māori authority, tikana over taonga tukuiu. More so in environment, the management, and the cultural heritage, Māori whenua, where we are treated as second-class citizens. This bill undermines our tino rangatiratana, our tipuna knowledge systems, that this regulatory bill is reducing our Māori values to compliance issues rather than a living taonga. This bill is institutional and does not allow us Māori to engage with state power. The violation of Māori intellectual property rights. Cultural rights, pēnei te kapahaka, waiata, te reo, armed forces are not protected within this proposed bill, and I shudder to think about it. This bill lacks protection and mechanism that upholds our Māori ownership and kaichakitanga over mātaurana Māori and our whenua Māori. It supports individual commercial ownerships over intellectual properties that contradicts communal Māori systems of ownership, mana whenua, and integrity. Without protection over tangata whenua status, this bill opens the gates to cultural appropriation without Māori consent. Māori knowledge is sacred and risks become data for private use, which is detached from our spiritual whakapapa and cultural roots. Māori soldiers' contribution to wars. This regulatory standards bill enforces and standardizes national criteria, threatens to marginalize Māori accounts to global wartime contributions. Māori wartime identity is observed on Anzac and Armistice Day on our marae to construct living identity through oral presentations grounded in our tipuna. Sacrifices from both world wars and following military engagements, such as Korea, Malaya, Borneo, Vietnam, Bosnia, Solomon Islands, East Timor, Iraq, and Afghanistan. Lives were lost in these campaigns after both world wars. The sacrifice and bloodshed provided a comradeship between Māori and Pākehā in all forms of military engagement. We were one people then, and we still are today. Māori contributions risk erosions from the national military landscape that diminishes the ability to call the courage of shaping our contributions to global wars. I am reminded of our Tue Māori Battalion veteran Sir Blom Gillies. If he had known the treatment accorded on their return, he would not have served. Today I stand by that kōrero because all the wars that have been taking place, even when I came back, the limited of care, rehabilitation, and unfair ballots to land was absolutely non-existent. Today, I stand by that kōrero, and when I say this, should this bill ever become law, I hope not. Let me elaborate to Mr. Seymour. E kore rātau e kore heketia, e kore hoki ko te rātau e noi kore, ahakoa pēhea nā hua tanau te wā. A te tōnau te rā, taino ki taranga I te ata, ka maumahara tanu tātou kia rātau. They shall not grow old as we that are left grow old. Age shall not weed them, nor the years condemn. For at the going down of the sun, we will always remember them. Treaty of Waitangi comments. Prior to the 28 Māori Battalion departing the shores of Aotearoa, Te Apirana Ngāta selected a guard of honour from the 28 Māori Battalion and took them to the treaty grounds and performed a haka on Waitangi Day. That performance details the recognition and respect of the Treaty of Waitangi by Māori soldiers who were proud of their heritage, the mana and the ihi of their marae hapu prior to departure to battle in 1940. Violating the treaty within this bill and given their sacrifices for the price of citizenship in World War I and later in World War II ended in victory from both wars. Yes, they paid the supreme price and loss of life, wounded for life, and this bill risks a monocultural policy effectively silencing Māori wartime voices. As a result, the risks detached from the moral and spiritual weight of Māori contributions to global conflict, and I refer to Rongo Māori in this case. Seymour's bill to amend the principles of the treaty to unite Māori people of this nation is nothing but showmanship. Trunking with the treaty to become one people is nothing more than wishful thinking. His comments to the treaty is not for everyone, and by using this bill to enable him to amend and violate the treaty just to benefit one man, Seymour and his minority party. I refer to Seymour and his bill. As the chiefs were signing the treaty in front of Lieutenant Governor General Hobson in 1840, he shook hands and he said to each one of them, "He iwi kotahi tātou." We are one people. 150 years later, we still are one people. During our engagements overseas, all military units were known as Kiwis. This brand stood out that identified soldiers all around the world. For example, Kiwi brand for music, Kiwi brand for marketing exports, Māori in arts and culture. His reasoning to amend the treaty to become one people is pure nonsense. E kuare ki ngā tika no te tiriti me te wairua o tāua te tanata. Ignorance of the treaty is no excuse. In summarizing, o taku reo te o hoho, my language is my sustenance. O taku reo te māpihi mauri, my language is my soul and spirits. This bill has the potential to take away our reo mana whakapapa entity and our rights through tihahai tō tāua reo, ripping up the treasures of our language, threatening our whenua Māori. This legislation neglects and fractures vital relationships that retains Māori tikana, customs, sacrifice, heroism, and humility. This bill represents a violation and breach of the Treaty of Waitangi, which affirms the rights of Māori to implement tino rangatiratanga over our taonga tuku. Disempowering our Māori voice, undermining constitutional integrity, displacing Māori frameworks of tikana Māori, loss of our cultural values destroyed, no right to challenge the laws. The leader of the ACT Party should stand up and recognize that no matter what he throws at us as a Māori, we may fall, but we arise with determination. Inheritance of our lands is not for sale. We are clever people who know how to conduct and lead our own commercial and social enterprises, managing our visions and future. We can do this successfully without the introduction of this koretake bill. And I seek the indulgence of National Party and New Zealand First, my chokanas, Winston and Shane, to turn their backs, close away, and disregard this bill in its entirety. Today we converse eye to eye with a person, but when she or he is not in our presence, they will ridicule us, and speak with different tongues. That is what that proverb means. To remove the entirety of this bill by not supporting it, in closing, the entirety of this bill, we will not support. We turn our backs on it and we won't vote to it. And I refer to the late Professor Raymond Walker's book, Ka whawhai tonu mātou, ake ake, ka tiaki rai konei, tēnā koutou, kia ora tātou katoa.
Okay, thank you very much, sir. We're over time, but we appreciated that fulsome and forthright presentation from you this afternoon. Thank you for joining the committee. Thank you for submitting both in a spoken sense and in writing too. We really appreciate that. Wish you all the best for the rest of the week. Thank you. Okay, members. Dr. Glass, have we got Dr. Barber and Ms. Jones on board?
We have Coena Jones and Kirsty Barber online now.
Okay, let's go. Thank you.
Ka pai, tēnā tātou. Thank you for your time. Apologies in advance for any coughing interruptions. Just by way of quick introduction, my name is Coena, though most people just know me as Kawi. I'm the co-director of Toa NZ New Zealand. And I'm also joined here by my colleague and co-director, Dr. Kirsty Barber. So Toa NZ is making this submission to express our strong opposition to the Regulatory Standards Bill because it constitutes dangerous constitutional reform with far-reaching implications for all New Zealanders. Taurikura is a social enterprise engaged in civics education, democracy, sustainability and cultural capacity for organisations, communities and hapori Māori. Our name envisages an Aotearoa where all thrive and flourish. We do not think we have anything unique to add to the arguments and evidence presented already by scholars and experts from throughout our social institutions such as judiciary, public and environmental health, economists, the Waitangi Tribunal, the Human Rights Commission, and many others, a list that now includes GCSB and SIS. But we're here to support all these other esteemed New Zealanders in vigorously opposing the Regulatory Standards Bill and the flawed process of its introduction. In brief, the RSB is anti-democratic and ignores advice, evidence and expertise of our established democratic institutions and will harm our people, communities and environment. It overstates the role of political parties in government, undermines the role of the Crown as a treaty partner and overrides the principles of good governance. I'll hand it over to Kirsty.
Kia ora mai tātou. Our first point is that there is no problem that this regulatory standards bill actually resolves, and there's no evidence that we don't have currently sufficient regulatory frameworks. We already have vital checks and balances. We have the Cabinet Manual, we have regulatory impact statements, so a lot of that was redacted or whatever for, as part of the evidence that was either ignored or redacted in the introduction of this bill. We also have parliamentary scrutiny through select committees. This bill, as Kawi just pointed out, is proceeded against the advice of the Ministry of Justice, the Waitangi Tribunal, the Human Rights Commission, scholars, economists and legal experts. David Seymour's own Ministry of Regulation has advised them that neither of his bills, I mean the Treaty Principles Bill as well, has met their own proposed regulatory standards. They're not necessary, nor will they achieve what he says they will, and that's from his own ministry. This means that the introduction of this bill is dishonest and divisive. It's not an ethical, responsible or thoughtful way to make laws. Introduction of this RSB by the coalition government overstates the roles of political parties in government. It undermines the role of the Crown as a treaty partner. I'm sorry, I think I'm just repeating what Koe said. Sorry, Koe. And overrides good governance. It's worth repeating, I think. It unduly prioritises agreements between political parties, and in this case, the ACT Party's narrow ideological theory, pardon me, over respecting, protecting and upholding a government's obligations to democracy and our systems of government. In fact, the introduction of this bill has enabled a minor political party to bypass democratic processes that have already rejected this bill multiple times. The RSB is a huge cost to taxpayers of a totally unnecessary legislation that undermines our democratic norms and guardrails. Back to you, Koe.
The introduction of this bill, like the Treaty Principle Bill before it, has damaged our social cohesion and ignored the advice and expertise of our established and democratic institutions. Not only has the protest been anti-democratic, lacked transparency and ignored all redacted advice and evidence that abuses our established political processes, as it is a stain on our democracy. David Seymour's claim that the bill would codify regulatory practice for existing and future regulations is demonstrably false and misleading. Most ordinary working people will be negatively affected in their workplaces, communities and natural environment as it undermines key protections. In addition, the RSB creates shocking ministerial overreach. The ministry would become an unaccountable central authority with undue influence over legislative and regulatory decisions. It undermines the role of judicial scrutiny and overrides the principles of good governance. It would grant the Ministry of Regulation and a non-elected Regulatory Standards Board disproportionate powers over other ministries, agencies and government departments. It ignores good governance by prioritising the interests of corporations and the wealthy, taking power away from communities and shifting power away from Parliament, whose role it is to balance different interests. It is not good policy or legislation. We call on National and New Zealand First to abandon this bill. I'll hand it back to you, Kirsty.
The Regulatory Standards Bill is an attempt to shift our constitutional frameworks by stealth. Any constitutional change should be developed on a carefully considered, evidence-based, bipartisan basis, ensuring that there's robust conversations and debate and input from a wide range of community interests, as well as our independent and democratic institutions. The RSB undermines the basic principles of our representative participatory democracy and the separations of powers, and that's from the Constitution Act. It also creates a fundamental constitutional shift by enabling the repeal of treaty provisions in existing laws, future lawmaking, public services and regulatory systems. Te Tiriti o Waitangi guaranteed Māori not just democratic participation like all citizens, but also a voice in the design and establishment of our constitutional arrangements. The social license of our democracy requires that all of us have the right to be represented, our voices heard and respected. Yeah, that's a bit of a joke at the moment, on decisions that impact our families, communities and environment. This bill would limit the power and flexibility of Parliament, undermining its critical responsibility for scrutinising proposed legislation on behalf of the greater good. Our constitutional framework must not be determined by one political party's ideological whims. Back to you, Koe. Oh no, sorry. I don't know why it's me. Sorry.
Yeah, we're just into the last minute, guys. So if we can just.
Oh, are we?
Yeah.
We've got 8 minutes. We're an organisation. We've got 8 minutes.
You've got 10 minutes.
Yeah.
Yeah, you got 10 minutes, and we've got a couple of minutes to go. So I just want you to do your conclusive remarks, and then ask members for questions.
Okay, that doesn't seem the rules that others have been held to, like the New Zealand Initiative this morning. So basically, just to follow through, the RSB, another huge issue that we and others have is that it prioritises individual and property rights over the collective rights. We live in communities and societies, and it weakens protections for communities, societies and the environment. Absolutely behaves as though the Treaty of Waitangi does not actually exist, breaches our obligations to our treaty partners in multiple ways. Koe, do you want to step in?
No, if you can just do the conclusion, please.
Oh, okay. Our conclusion is that effective regulation is vital for our communities and our future generations. There is no need for this bill. It solves and resolves no issues and has no democratic mandate to proceed. Representative democracy and good governance are about developing laws for the greater good of all communities and looking ahead to the future. They should never be about making a profit for shareholders or the funders of political parties. Protecting our democracy is a shared responsibility and a solemn challenge. The RSB does not have a sustainable social licence and would further erode trust and confidence that our democracy works for everyone. The RSB weakens protections for vulnerable communities, public health, income security, workplace safety, and the relationship between partners of Te Tiriti o Waitangi. It will exacerbate environmental degradation and lead to untrammeled development, resource exploitation, and pollution. There is no democratic mandate for constitutional upheaval of this magnitude. It erodes our democratic processes and will give unprecedented power to wealthy corporate interests while ordinary New Zealanders lose their vital protections and their democratic voice. This bill must be abandoned in perpetuity. No amendments would address the fundamental and ideological inequities and failings at the core of its conception. Kia ora.
Kia ora. Okay, thank you. Very good. With inside your time, members, we've still got an opportunity for a question if anyone's got one. Well, there you go. A very fulsome and clear presentation to the both of you. So thank you for your submission. Thank you for your time and thank you for your patience. And we wish you all the best for the rest of the day. Thanks for being part of the process. Thank you. Okay, that takes us to I think we're in person for the Victoria University's Students Association. Is that right, Dr.
They're here online.
On Zoom. Okay, very good. Welcome.
Kia ora.
Yep, kia ora. Introduce yourselves, and we look forward to the 10 minutes. And as you've seen, if you leave us a bit of time at the end, there might be a question or two.
Sweet, thank you. Kia ora koutou, my name is Laban Ali. I am the president of Te Akatoa VUSA, so the Victoria University of Wellington Students Association, and I'm here to submit on the Regulatory Standards Bill. So yeah, we represent over 20,000 students, many of whom are struggling right now with the cost of living crisis, insecure housing, and an education system that's under pressure. Today, I'm not here to go deep on Te Tiriti implications or the constitutional risks of this bill. Other submitters have done that well this week. We believe debating a bill that nobody asked for, that's already failed multiple times, and that's widely out of step with what everyday New Zealanders actually care about, is just a waste of time. Let's be honest, the bill didn't come from a groundswell of public demand. It's been around the block, first introduced in 2011, reintroduced in 2021, and now again in 2025. Each time it's failed to gain traction. It keeps getting repackaged and brought back to life like a bad sequel nobody asked for. This isn't about improving regulation, it's about embedding a very specific ideological agenda that treats government action as a problem to be restrained, not a tool to support people. At the last election, the ACT Party got just 8% of the vote, and yet looking at this government's current agenda, you'd be forgiven for thinking David Seymour is running the country more than Christopher Luxon. It's hard to tell if this is a coalition or a quiet takeover. When a party with a fraction of the public mandate can drag Parliament into weeks of a hearing on a fringe economic theory while the public deals with skyrocketing rents and grocery prices, we have to ask, who is this government really listening to? While we're here debating an ideological wish list, people are choosing between rent and food. Students are working multiple jobs to make ends meet while trying to study full-time. Families are struggling with unaffordable housing and rising interest rates and long waits for basic health services. And yet somehow this is what's getting this legislative spotlight. It's deeply out of touch with what matters to people right now. This bill doesn't build a home, it doesn't cut a power bill or improve a single person's life. It makes it harder for governments to act even in emergencies and easier for powerful groups to challenge progress in the courts. It treats regulation like a burden when in reality, good regulation is what protects renters, it's what protects workers and our environment. Students rely on good regulation. Students rely on tenancies laws to ensure their flats are livable. We rely on employment protections and insecure work. We rely on public transport subsidies to get to class. We rely on climate regulation to protect our future. The idea that regulation is inherently harmful just doesn't match the reality we live in. This bill is based on the idea that we need more oversight on how laws are made, but that's not true. We already have robust processes, public consultation, select committees like this one, regulatory impact statements, and judicial review. This bill doesn't strengthen democracy, it adds an extra layer of bureaucracy. It gives legal ammo to lobbyists, not ordinary people. Parliament only has so much time and capacity. Every hour spent on this bill is an hour not spent on addressing housing, addressing education, climate, health, or inequality. People are desperate for leadership, not ideological side quests. And I guess my final word to the committee, this bill is tired, unnecessary, and out of step with the moment we're in. It reflects the priorities of a party with only 8% of the vote, not the wider public. It's been rejected before, and I believe it should be rejected again for good reason. We urge you to reject it again and focus on the urgent issues New Zealanders are actually calling for action on: affordability, dignity, and a future we can believe in. Thank you.
Thank you very much. Very concise. We have got room for questions if any members have got any or seek further clarity. Okay, we're going to go to Takeda Ferris. You're just on mute, Mr. Ferris.
Hey, kia ora, Cameron. Tēnā koe hoa i o mahi pai. You know, there's a fairly large disjoint between the views and the aspirations of your generation and the workings of the current generation and its makeup. You know, the people in power government, I mean. What do you think are the key considerations around policy and lawmaking that you would rather spend time on, or that you feel are at the forefront and need time spent on, rather than what we are doing here with the RSB, rather than what we did with the Treaty Principles Bill and a raft of other bills? What are the key things for you guys?
I guess the key, thank you, Takuto, for the question. I guess the key things that we want our government to focus on right now is actually having a sustainable job market right now. Most of our graduates and students are struggling to find jobs after they graduate, which is rubbish. And when they end up hopping on a one-way flight to Australia and UK, government just chooses to bash down on them, saying that there isn't anything happening in New Zealand, so we understand. But in reality, it's up to the government to actually address these issues. I'm tired of David Seymour's agenda being pushed before actually addressing the issues that are faced by normal New Zealanders. I'm sorry, we just don't have time for the regulatory standards bills. It's rubbish.
Okay.
Kia ora, kia ora.
Right. Okay. No, thank you. Thank you for representing the Students' Association at Victoria University this afternoon. We appreciate your time and your submission. Thank you. Okay. Madam Clerk, that then takes us, let me have a look here. Where are we at now? Oh, we're at the Association of Salaried Medical Specialists. Are they in person?
And they're online, and we have Dr. Katie Ben.
Okay.
Apologies, my flight was redirected back to Wellington. The weather here is terrible.
Okay. Whereabouts are you coming from?
So, kia ora, my name is Katie Ben. I'm an anaesthetist at Nelson Hospital. And
okay.
Talking to you from a very, very fogged in low base of Nelson Cloud. I am also the president of the Association of Salaried Medical Specialists, which is the union for senior salaried doctors and dentists. Our members comprise over 85% of the senior medical and dental workforce employed by Te Whatu Ora. You have a written copy of our submission, which I take as read. But today, I'd like to explain why we consider that this bill will be detrimental to the health of New Zealanders, using examples from my own clinical experience. The Association of Salaried Medical Specialists is opposed to the Regulatory Standards Bill, and we recommend that the bill is discarded. We are concerned that the bill will have significant negative consequences for the health of all New Zealanders. And we've got three key reasons for this. The first is that the principles of responsible regulation are narrow and leave no room for health. The second is that the Regulatory Standards Board, which will be created, will open a direct line for the lobbying from commercial interest groups. And the third, which has been said by many and will continue to be said, is that the bill omits any reference to Te Tiriti o Waitangi, and it will exacerbate the already stark inequities in health between our Māori and our non-Māori patients. So firstly, the narrow principles in this bill will make it much harder for governments to regulate to protect health. Regulation is very important to protect the health and safety of New Zealanders. We have regulations that govern how tobacco products and vapes can be marketed. It sets minimum standards for safe and healthy rental properties. It sets minimum standards for health and safety at work. These regulations are going to impact the profits that you can make in those commercial sectors. But exposure to tobacco smoke and vape products, living in those damp and mouldy homes and being injured at work is a cause of significant preventable illness and injury to New Zealanders. We need regulations to prevent or limit the extent of illness and injury that our New Zealanders suffer. It is heartbreaking to wake up a child when you know one or both parents smoke at home. It doesn't matter if they only smoke outside. Those children struggle for breath as they are waking up from an anaesthetic. They cough, they choke, their oxygen levels drop. It is hard watching those children go through this very traumatic wake-up experience when a very simple minor procedure should actually not cause that much risk to their health. It is heartbreaking knowing that you are going to send those children back into that smoky household environment. Okay, Section 8 of the bill outlines a very narrow set of principles for responsible regulation, which focus on the property and the rights of the individual and doesn't factor in the wider public good. It doesn't factor in public health or equity or protecting the environment or protecting that child. Basing our regulation on this narrow set of principles could mean that the health impacts on New Zealanders are not considered, or that company profits are deemed more important. For example, we could see the profits of those tobacco companies being prioritised at the expense of the health of our patients. And it's really obvious when you look at the fact that health harms cannot be summed into a simple dollar figure. Twice a week in Nelson, we have an operating list that takes out the teeth of children who have suffered from sugar-sweetened beverages, ultra-processed foods, bad advertising legislation. They have dental decay. They are difficult to look after. They have their teeth removed, which impacts their smile, it impacts their ability to feed, it impacts their ability to function at school. And when you're talking about healthcare as a finite resource, it takes away the operating theatre time, the surgeon, the anaesthetist, the tech, and the nurses, which could actually be diverted into other operative procedures that New Zealanders require. When you get an asthmatic that comes in through ED from a mouldy house with another asthma attack, and you work your butt off to get them alive and through the night, and actually it's really scary. It's one of the scariest things I do as an anaesthetist, is to put an asthmatic on life support, because sometimes it's 50-50 as to whether you'll be able to save them. And when you do save them and you put all that health resource into this person because you want them to go home, they go back home to a mouldy house. And you know they're going to come back in a week or 2 weeks or 3 weeks with the same health problems. Our health system is under significant pressure. We have escalating demand for care. We have entrenched shortages of doctors. New Zealanders are expecting unmet need. We have a really highly trained, highly skilled workforce. It's got a world-class safety record. This bill risks the introduction of a lesser qualified workforce, which will harm patients, and we've seen that already in evidence overseas. It's critical that governments take health into account when they're making their laws and policies, and it's critical that they are allowed to effectively regulate to protect our public health. This bill will not lead to lawmaking that prioritises the health of New Zealanders. It will limit the ability of governments to regulate to protect public health. In turn, it will increase pressure on our health system, and it is going to massively increase the cost of providing that healthcare. The second point is that the Regulatory Standards Board is going to open a direct line for lobbying from commercial interest groups. This bill establishes that board, as you know, and it will be an appointed board of about between 5 and 7 members that will assess the legislation and consistency with the principles. They're informed by a system where if complaints are made that legislation is inconsistent with those narrow principles, they could be open to lobbying from industry groups. Now, this is a small group of people appointed by the Minister for Regulation, which would be affected by lobbying. We know that the tobacco, the alcohol, and the ultra-processed food industries are already shaping our public health. They are already going to extreme lengths to protect their profits at the expense of the health of our citizens. The threat of lobbying from these groups is going to intensify under the bill, and this will have a chilling effect on the appetite of governments to regulate to protect the public from the commercial determinants of health. We need accountability for decision-making in healthcare, and given that this bill has the potential to increase our preventable harm, who is going to be held accountable for that? Finally, Te Tiriti o Waitangi is absent from the bill. This bill will negatively impact the health of both Māori and non-Māori patients, but the disproportionate effect of that harm is going to fall on our Māori population. We know our health system needs to perform better for Māori across the board. We know they don't have equitable access to healthcare. I've audited our admissions in Nelson Intensive Care Unit. Our Māori population is massively underrepresented for what you would expect for our population to be. And yet, in the same figure, they are massively overrepresented in our mortality figures. Now, that's just not fair. They don't have access to the service, and when they manage to get in, they're more likely to die. We know that they have different levels of exposure to determinants of health. They suffer from deprivation. They're more likely to have damp housing and food insecurity. We've already got stark inequities in outcome between Māori and non-Māori. It starts in childhood, and it grows throughout their life. It doesn't have to be like that. We can have practical actions taken to improve Māori health, but that doesn't happen with this bill. We can ensure Māori leadership in health service design. We can address those social determinants of health. We can upskill our health workforce to be culturally safe and competent. And we can reflect all of that in our regulatory principles, which this bill does not do. If we get it right for Māori, we would get it right for everyone. Omitting the treaty from this bill will negatively impact the health of all New Zealanders, but the harmful effects will exacerbate the already inequitable health outcomes with our Māori and non-Māori populations. In conclusion, we are aware that many experts and government officials have expressed doubt that the bill will achieve its purpose in promoting accountability for developing high-quality legislation. We're also aware that the bill does not have broad-based support and it will be repealed by the next Labour government. On balance, we consider that the health risks posed by this bill are high and the likelihood of the bill improving any legislative process is low. And again, we would therefore recommend that this bill is discarded. I'm not sure if I have time for questions.
You're on mute, Cameron.
Sorry, thank you, Deborah. You probably don't have questions, time for questions, Dr. Katie Ben, but because of the good work you're doing in Nelson and your forthright submission, I'm going to give one to Dr. Deborah Russell.
Okay, thank you. Look, first of all, thank you for those comments about children. Maybe realise a little bit more clearly that property rights typically attach to adults, and so this bill, the way it's formulated, excludes children from citizenship, which is, because they're just excluded from it. Look, I really take on board your comments about Māori health and the discrepancies there. We're sadly familiar with them, not in the detail that you are, but obviously we know that story and it's horrific. Do you have any similar information about Pacifica Health, or do you see a difference there as well? Is that something you would be concerned about or think might be improved, oddly enough, by adding Te into the bill?
I don't have any information relating specifically to Pacifica Health, but I do know that from previous studies and previous works by other people that if you improve Māori health, you automatically improve the health for all of the non-dominant, if you like, population. So you don't just improve Māori health, but you will improve Pacifica health outcomes. If you can improve access for Māori patients, we'll improve access for our Pacifica, for our Indochina, for our Mayan refugee population, as well as for our Pakeha population. It is not a zero-sum game. Improvement for one doesn't have to mean not improvement for the rest.
Okay.
Okay, thank you.
Very good. Thank you, Dr. Ben. Thank you for your time. I'm sorry about the weather and the missed flight and everything else, or the cancelled flight, but you're home and looking warm, and we appreciate the time that you've given us today and wish you all the best with the good work that you're doing.
Kia ora. Thank you very much.
Kia ora. Okay, Madam Clerk, does that leave us with next to Ms. Jensen Butler?
Yes, she's online now.
Okay, Teresa. Okay, let's put her through. Kia ora.
Kia ora. Tēnā koutou katoa. Ko hikirangi te maunga, ko wāpu te awa, ko hini mauria ki wharikahika te marae, ko te whānau a tūwhaki iri order te hapu, ko Ngāti Porou te iwi. Ko Teresa Werehiko Jensen Butler aho. I am one of the activators representing Toitū Te Tiriti o Tautahi. Toitū Te Tiriti o Tautahi is a grassroots movement based in Ōtautahi, Christchurch. We are tangata whenua, tauiwi, parents, artists, rangatahi, activists, educators, environmental, kaitiaki, and community workers who believe in a tiriti-based future, mokopuna-focused, tipuna-driven. We were born from the need to respond to the growing threats to Te Tiriti o Waitangi, threats not only in policy, but in practice. Our movement is grounded in whakawhanaungatanga, solidarity, collective action, and tino rangatiratanga. During the biggest hikoi in Aotearoa's history, thousands of our whānau from across the motu came together in unity, each person laying their hands on atawhai and placing their mauri within her. She became a living vessel of the people's wairua, their hopes, struggles, and collective strength. Today, we stand here. We do not come alone. We carry the mauri of Ōtautahi Waitaha and the heartbeat of an entire nation. Māori and non-Māori alike are woven into this kaupapa, walking side by side, standing for justice, honouring te tiriti, and upholding the mana of those who have gone before us. We would like to begin by acknowledging the mana of our kaumātua and whānau of Tuahiwi Marae, who have supported our kaupapa from the very beginning. In particular, we honour Atawhai, who was gifted to us from them, the taonga of Pounamu, that travels now with our movement, a reflection of our tipuna and a reminder of the intergenerational responsibility we carry. Our Pounamu Atawhai represents compassion, strength, and endurance. These are the values we bring into the space today. This bill might be framed as a technical change to how laws and regulations are written, but as we see it, it is a structural attack on te tiriti, on whānau Māori, and on our ability to care for each other and the whenua. It creates a rigid legal framework that prioritises property rights, economic efficiency, and individual liberty at the cost of collective well-being, kaitiakitanga, and mana motuhake. This bill tells us that the interests of business and private ownership come before the rights of tangata whenua, before the environment, and before the needs of future generations. It tells us that profit matters more than people, and certainly more than te tiriti. This is why we care, and this is why we are here. Our concerns with the bill are: it undermines te tiriti o Waitangi. The bill fails to uphold te tiriti, no, not in words nor in practice. It reframes rights through a Pākehā lens, property, market freedom, minimal government interference, but te tiriti was never about those things. It was about partnership between rangatira and the Crown, built on mutual obligation, respect, and shared responsibility. Te tiriti guarantees Māori tino rangatiratanga authority over our own lives, lands, and taonga. This bill says nothing about that. It reduces regulation to cost-benefit analysis, and in doing so, it silences te ao Māori and removes the relational and collective values that our systems so desperately need. It harms all whānau, Māori and non-whānau. In Ōtautahi, our communities are already struggling. Housing unaffordability, rising food costs, access to healthcare, broken infrastructure. The Regulatory Standards Bill will make it harder for governments and councils to pass laws that protect housing, public housing, wages, health, and climate response, because all of these carry costs. When costs to business becomes more important than care for people, it is our whānau who suffer. This bill will affect whānau katoa, Māori and Tauiwi, because it strips away the power of the state to act for the public good and replaces it with a free market ideology that rewards the already powerful. It endangers our environment and future generations. In Waitaha, we live with earthquakes, flooding, and rising sea levels. We know what environmental vulnerability looks like. This bill makes it harder for councils to regulate environmental protection because it places burden on justification on every rule, every standard, every limit imposed on industries. Our tamariki and mokopuna will live with these consequences. We cannot regulate to protect the climate, to ensure clean water, to safeguard biodiversity, then we are leaving them nothing. The bill focuses on short-term economic costs, comes at the expense of long-term environmental survival. Our recommendations to the Select Committee: we believe this bill should not proceed in any form. However, if you are truly committed to listening, to partnership, and to a tiriti-based future, we offer the following 4 recommendations. Withdraw the bill in its entirety. It is fundamentally incompatible with te tiriti or Waitangi. No amount of amendment can resolve a foundation that is flawed. The bill creates a dangerous precedent for awakening regulatory protection and undermining collective well-being. centre Te Tiriti Waitangi in all legislative frameworks. Te Tiriti must be an active and binding foundation for any law in Aotearoa. That means co-design with hapu and iwi. It means recognising tino rangatiratanga, not marginalising it. It means Te Tiriti is not just a consideration, it is a constitutional commitment. Empower local and central government to regulate for collective good. Our systems must enable, not prevent, action for housing, climate, food systems and health, especially in emergencies, especially when lives and whenua are at stake. Cost-benefit frameworks should never override our moral, cultural and environmental obligations. Safeguard the rights of our future generations. All legislation should be assessed not only for current economic costs, but for intergenerational impact. What kind of Aotearoa are we leaving our mokopuna? Are we creating laws that serve the now or laws that sustain for the next 100 years? A tiriti-based intergenerational and environmentally grounded framework is not just possible, it is essential. We urge this House and Select Committee to uphold your responsibility to protect all communities across Aotearoa, especially when we engage in robust democratic debate. During our hikoi in Ototahi, standing peacefully with our tamariki, we were met with hostility, threats and degrading behaviour from right-wing extremists opposing Te Tiriti or Aotearoa Hou. No whānau, no child should be subjected to such harm for exercising their right to participate in this nation's future. The Regulatory Standards Bill, if passed, risks further embodying these threats by undermining the rights and protections of those who speak out. The bill undermines the rangatiratanga of Māori, the role of government to act for the people, and the kaitiakitanga we owe to Papatuanuku and our tamariki. Atawhai is not just a gift of pounamu, but a gift of purpose. To act with compassion, to stand with integrity, and to speak up when justice is dressed in legal language. This bill does not serve the people, it does not serve our whenua, it does not honour Te Tiriti o Waitangi. We urge this committee to reject it in full. Toi tū Te Tiriti, toi tū te mana o te tangata, toi tū te whenua, toi tū ngā mokopuna o Apopo. Nō reira, tēnā koutou katoa.
Thank you, Teresa. Thank you very much. Unfortunately, we haven't got any time for questions. We've exceeded time, but we thank you for your submission and taking the time and the energy to express your views this afternoon to the committee.
Kia ora.
Kia ora. Okay. Now we've got scheduled Young Greens Aotearoa. Is that right, Madam Clerk?
Yes, they're online now.
Okay, very good. Does that make Mickey Treadwell an old green if you guys are the young greens?
Maybe.
Don't worry, I get lots of old Nat comments too. So hey, look, we look forward. Thank you for taking the time. You've got 10 minutes. I'm not going to waste it, so it's all yours. We're in your hands. We look forward to it.
Kia ora. Tēnā koutou e te komiti, ko Taranaki te maunga, ko Waitara te awa, ko Aotearoa te hapu, ko Maioha Hunt tōku ingoa. I'm currently one of the co-conveners for the Young Greens and soon to be a student at Waipapa Taumataro, the University of Auckland. Today, I'm also joined by two members of the Young Greens exec. I'll let them introduce themselves to the committee.
Tēnā koutou katoa, ko Te Atiawa Taranaki Raua ko Ngāpui te iwi, ko Puki Tapu Raua ko Ngāti Pako te hapu, ko Autumn Brown tōku ingoa. Tēnā koutou e tēnei ahi. I'm currently in my third year on the exec and second year on the exec for the Young Greens of Aotearoa as a social media person.
Tēnā koutou katoa, e te taha o tōku māma, ko Ngāti Pororātou, ko te whānau kai, ko rongo whakata, ko Ngāti Kōtarani o ku iwi, e te taha o tōku pāpā, ko te Atiawa ki Taranaki rātou, ko Ngāti Teina, ko Ngāti Ingarahi o ku iwi, no te tairāwhia hau, Ko hena overby tōku ingoa. Kia ora tātou. I'm currently the pōtikanga for the Young Greens, my role being to ensure our mahi as the Young Greens of Aotearoa upholds the wider party's commitment to Te Tiriti o Waitangi. I'm also currently a postgraduate student and mentor at university.
Ko Young Greens Aotearoa mātou, we are Māori exec members from the youth wing of the Green Party. He rōpū rangatahi mātou, e tū rangatira ana mo te taiao, mo te tika, me te mana o te tiriti o Waitangi. I want to open up our submission by thanking the committee for granting us the time to speak to this bill directly by having an audience with you and the public. I'd also like to give a mihi to the many people and organisations who have spoken before us in opposition to this bill, those who will be speaking after us, and to those who will frustratingly not get an opportunity to put a voice to their submission. It is very peculiar that the author of this bill claims that it will bring transparency and improved consultation in future lawmaking processes. We believe that public consultation is a cornerstone of our democracy and should not be compromised. The decision to reduce the oral submission time for this bill to 30 hours, less than half of what was allocated for the Treaty Principles Bill, is a clear violation of this principle. As Māori members of the Young Greens exec, we are proud to join the overwhelming chorus of opposition to this bill. The decisions that we make today will have a lasting impact on Aotearoa for generations to come. It is rangatahi like us that will have to deal with the detrimental consequences of bills like the RSB, should Parliament pass them. We submit in strong opposition to the Regulatory Standards Bill. This bill is a backdoor attack on Te Tiriti o Waitangi, democracy, and the values of manaakitanga and kaitiakitanga that underpin a thriving future for everyone. In our submission, we will seek to explore specific areas where we believe that the RSB would impact our futures the most.
The first reason we oppose this bill is because it is constitutionally dangerous. This bill gives enormous power to an unelected Regulatory Standards Board, removing decision-making from tangata whenua, communities, and future governments. That's not democracy. That's corporate capture dressed up as regulation.
The second reason we're opposing this bill is it's a breach of Te Tiriti o Waitangi. The Waitangi Tribunal confirmed that the Crown failed to consult Māori on the Regulatory Standards Bill and that the bill itself violates the intent and application of Te Tiriti o Waitangi. Not consulting Māori, tangata whenua of Aotearoa, and signatory to Te Tiriti o Waitangi, our constitutional document of covenantal importance to this land and its ability to exist as a nation known as New Zealand today, is unacceptable. The bill's focus on economic efficiency and formal equality threatens efforts to address systemic and historical injustice towards marginalised populations, and specifically to Māori. We, as the Young Greens of Aotearoa, fear that this bill will impact initiatives that aim to address the overrepresentation of Māori in negative health, justice, and poverty outcomes, like the Ministry of Health Tauara Māori Strategy Pai 2 and the anti-racism policy Ao Mai Te Rā, which both put an emphasis on upholding commitments to Māori under Te Tiriti o Waitangi. We believe that this government should implement policies and strategies that aim to advance better outcomes for all, whilst paying specific attention to the commitments and obligations bestowed upon them by virtue of their governing structure, which is kāwanatanga. A governing structure which came into being through negotiation with Māori, and which, embedded within the structure itself, must afford Māori equal treatment, as well as allow Māori to continue to be Māori in accordance with the relational principles we hold with our homes, our land, and all that we treasure. Te Tiriti o Waitangi promised Māori the maintenance of our original relationships with our taonga, and that was one of te rangatiratanga. In the gifting of kāwanatanga capacity to the Crown, Te Tiriti at the least offered Māori all the benefits the British sovereign offered his or her subjects. In the case of both the undermining of the exercise of tino rangatiratanga and the exclusion of Māori from access to the benefits assigned to Pākehā by the Crown, formal equality is not enough. Te Tiriti in this case would intend Māori to have equity, to get back to a place of firstly enjoying the right to self-determination over ourselves and our taonga, and secondly to enjoy the privileges assigned by the kāwana to their own British, now Pākehā subjects. Formal equality in the context of this country's contemporary governance structure and with the foresight of our history, only plasters over the wound of intergenerational hara, does not allow for productive strategies of moving forward together, and importantly, does not give Māori redress for the fundamental issue, the breaking of an agreed upon relationship. As a society, we agreed via Te Tiriti to protect Māori, and in turn all people of Aotearoa, through the maintenance of ways of being that comply to the nature of this land. The Regulatory Standards Bill is founded on the ethic of formal equality, that both ignores the history and mana of Te Tiriti and will not bridge the gap between the needs of vulnerable communities and the achievement of outcomes. A lawmaking process centred on formal equality rather than equity will only further entrench the negative outcomes that minority populations, including Māori in the context of a colonial nation state, are already overrepresented in.
Another reason why we oppose this bill is because it locks us out of a progressive people-first policy. Under this bill, future governments could be blocked from taking bold action on housing, on climate, fair wages, or restoring nature, simply because it might upset private profits. We believe papatūānuku is not a line item on a balance sheet. The RSB's explicit wording regarding formally consulting only those who are materially affected by the legislation leaves room for lawmakers to exclude the wider but still local communities that any decision or legislation might impact. Good lawmaking should always aim to widen the scope of consultation when possible, not to narrow it. For Māori, this might include hapu and whānau who have enduring links and interest to their whenua and tonga, but are left out of consultation because they may not fit into the definition of being materially affected by a decision on their whenua. But frankly, the most disturbing part of this is that the tino rangatira of these communities is at risk of being breached under this bill, also breaching Te Reti o Waitangi. Lastly, it goes against everything we stand for as Young Greens. Part of what Young Greens does is to deliver easy to digest and clear political content to our fellow rangatahi, especially when said content isn't really clear. But this bill is crystal clear. This bill threatens kaitikiitanga, mana mohutaki, and oranga tangata. Our vision is for a future that honours Te Tiriti, empowers rangatahi, and protects our communities and environment, not one dictated by a narrow business-first ideology.
Kia ora. And the final point we would like to make is that this bill is simply unwanted and unsupported. The overwhelming majority of submissions made on this bill did not support it. It has already been tried and tried and tried 3 times before, being rejected at each foul introduction. The futility of its current reintroduction is evident. Ultimately, this bill is nothing more than the ACT Party trying to push through long rejected policy through the back door in the interest of those who seek to exploit our whenua for their own selfish financial gain. However, the people have spoken. This bill must go. We strongly urge you, the committee, and members of Parliament to stop the progression of this bill. It does not serve the public interest, it does not reflect the values of Aotearoa, and it will have irreversible long-term consequences for both people and the planet. Finally, we recommend that this bill is discarded, or as Adam Curry previously suggested, throw it into the compost and use it in the mara. That way, we can at least be sure that something good came out of this horrid bill. Nō reira, tēnā koutou katoa, ngā mihi, and toi tū te tiriti.
Okay, thanks, guys. You're at time, but I'll just give Marama Davidson an opportunity to make a comment. Oh, we can't hear you, Marama. Okay, it's thumbs up. There we go. I think, and there's a lot of araha there. Oh, that's even more powerful than talking sometimes. Okay, thank you. Thank you, guys. Thank you to your co-leader too for participating. That takes us to, enjoy the rest of the day. We appreciate you submitting that. Takes us to the Climate Liberation Aotearoa group, and I understand they are queued up. Have we got Rosemary Penwarden?
She's online now.
She's online. Welcome, Rosemary.
Thank you.
You've got 10 minutes, and so don't let us hold you back. If you can accommodate a little bit of time at the end for any questions, that would be great too. Thank you.
All right, I will. Thank you very much. Kia ora, he tangata tiriti aho, I tipu aki o ti kia maui, e noho ana o I Aotearoa, ko Rosemary Penwarden, tōku ingoa. And thank you for the opportunity to speak. I speak on behalf of many hundreds of New Zealanders, many young people who are terrified of their future and determined to take action, including direct action, to save a livable future in the face of climate breakdown. I want to thank those who have spoken in opposition of this bill before me. Amazing speakers, those who yet have to speak and those who have not had the opportunity to do so, even though they asked to. And first, I just want to ask, why are we doing this? Why are select committee members having to sit here wasting everybody's time for the sake of this zombie bill, already thrown out 3 times by New Zealanders? Why? Well, I understand it was a deal done in order for this coalition government to get to power. If that is correct, to me, that is underhanded. The responsibility for this bill doesn't sit with ACT alone. It now sits with national MPs in New Zealand First. Now, Climate Liberation Aotearoa opposes this bill in its entirety. This is a bill of rights for corporations. The fact that it has even reached select committee demonstrates the urgent need for constitutional reform to protect citizens of New Zealand from executive overreach. The aim of this bill is to further embed and bind future governments to the illogic of economic freedom, libertarianism, by setting more rules and principles that will restrict future political decisions that do not align with far-right libertarianism, including those that impede corporate profits, like, for example, higher wages, better conditions for New Zealand workers, environmental protections, or justice, according to our founding document, Te Tiriti o Waitangi. The idea is to decrease government regulation so that free market has fewer restrictions and can make more profit. I'm saying it like this because I am sick of it. This has been since 1984. The Business Roundtable proselytized this kind of thinking. So I've had it for most of my working life. It was put into practice in 1984. It has led to the huge gap between rich and poor in this country today, and it contributes to the growing social problems we see, such as homelessness, child poverty, youth suicide, and many more. Now, I spent my career in the health system as a medical laboratory scientist, and I recall the salaried medical specialist's doctor who spoke earlier about children with asthma. So many children went to school where they were heated, their schools were heated with coal. Asthma is really huge in this country. Now, climate breakdown changes everything. More of the neoliberal agenda is the last thing we need. We need more regulation, not less. We know there's a better way. And this bill would take us in exactly the wrong direction. Instead of handing more corporations more power, we need to restrict them. Light-handed regulation results in negative outcomes for the people of this country. As proven, it's been proven. For example, Pike River, 19 New Zealanders went to work on the 19th of November 2010 and never came home. They were killed in their place of work, taken from their families forever because of light-handed regulation. Leaky Homes fiasco cost New Zealand
over $20 billion due to light-handed regulation. Forestry's shameful fatality rate is 20 times higher than average for all other sectors, thanks to light-handed regulation. Now, this is the fourth time the ideological right has tried to push this bill onto New Zealanders, this time as a result of horse trading by ACT and coalition talks, as far as I can work out. This coalition agreement refers to the actual passing and not just the introducing of this bill. So ACT, a minor party which attracted only 8% of the vote, is being allowed to bypass the democratic process that rejected this bill 3 times before. What? Where is the democracy here? Where is the fairness? Te tiriti o Waitangi, he whakaputanga, and the new UN Declaration on Rights of Indigenous Peoples, they're all absent from this bill. Even though ACT's treaty principles bill has been thrown out, this legislation would de facto have the same effect. Te tiriti would be removed from the list of considerations that inform regulation, including legislation aside from treaty settlements. In other words, a significant part of ACT's defunct and hugely unpopular treaty principles bill would become operative and constitute new breaches of te tiriti principles that the Waitangi Tribunal has already identified. This bill does not define the scope of property. Could it include mining permits and other licenses? Could it include carbon credits, fisheries quotas, cryptocurrencies, social media platforms, shares, all sorts of intangible intellectual property? None of it is clear. All of it would threaten our ability as New Zealanders to protect our people and our environment. Such legislation might disallow the introduction of climate change measures if they impinge on profits, or new restrictions on tobacco or alcohol, or introduction of a wealth or capital gains tax. These are things we seriously need. Designation of buildings as historic or land as outstanding landscape character. Recognition of the rights of mana whenua, of a whenua wai, or other taonga. Not renewing mining permits for climate or other environmental reasons. This bill gives more power to the minister. There's already a lack of trust in this government, as seen by the unprecedented number of ordinary people on the streets of Wellington in November 2024, peacefully protesting the Treaty Principles Bill. We are strongly opposed to the concept of making property laws a foundation for legislation over and above te tiriti rights, human rights, and regulations that support fairness, safety, and environmental protection. I am asking the committee to recommend the rejection of this bill in its entirety, as it has been justifiably rejected so many times before, and you have heard it over and over again. We need more checks and balances, not fewer. Unaccountable executive power is the last thing we need. Anyone wishing for a more democratic and fair New Zealand, let alone a survivable future, must reject this bill outright. That is including New Zealand First members and National Party members. This zombie proposal needs to be thrown out once and for all. Kia ora, thank you.
Very good. We are nearly at time. Have members got any questions for Rosemary? Otherwise, you've made yourself loud and clear. Thank you, Rosemary, for your time and for filling that 10 minutes and for your energy and your submission, both written and oral. And all the best for the rest of the evening.
Thank you.
Thank you. Okay, members, we've got Network Waitangi Whangarei. they're scheduled. Is that who we've got queued up? Oh, yes, we have.
Yes.
Oh, okay. I presume it's Catherine McKenzie.
That's right. Yep.
Oh, well, welcome. Thank you for your patience. Please proceed. You've got 10 minutes. If you would like an opportunity for some Q&A, then leave us a little bit at the end. But
okay.
Thanks for joining us this afternoon, Catherine.
Thank you. Thank you for your time. Tēnā koutou katoa. Ko Catherine McKenzie ahau, no Ōtautahi Christchurch ahau. E nai nei whangarei taku kāinga. I'm speaking today. I'm Catherine McKenzie, and I'm from Christchurch, but I've been living in Whangarei for the last 40 years. And today I'm speaking on behalf of Network Waitangi Whangarei. This is a pāhea organisation which has been involved in providing education on Te Tiriti Waitangi in Taraki Northland since 1985. We have been delivering workshops, public lectures, seminars, publishing and selling books. We run a website page and a YouTube channel. So we have been interactive with thousands of people in Taraki, in Northland over the past 40 years. And I've been involved in delivering education since 1994, treaty education. And this is information and education that has been ignored in our education system throughout our history. Thank you for the opportunity to speak here today. I will be echoing some of your previous speakers when I expressed Network Waitangi's absolute opposition to passing the Regulatory Standards Bill into law. And like some of the other speakers, our primary concern is that it ignores the critical place of Te Tiriti Waitangi in our constitutional framework. On the Ministry of Justice webpage, there's a heading Regulatory Stewardship. So obviously there's already regulation in place about regulatory standards. There's a subheading, Constitutional Arrangements to Treaty of Waitangi, the Treaty of Waitangi, and I quote, "This regulatory system deals with the place of the Treaty of Waitangi, Te Treaty of Waitangi, as a founding document of Aotearoa, New Zealand. The treaty established a constitutional relationship between Māori and the Crown." Quote. This Regulatory Standards Bill is an attempt to change our constitutional framework. Unlike most countries, we have an unwritten constitution. So we have no single codified document like the US Constitution. And so New Zealand's constitution is a mix of statutes, common law, and conventions. Under our current majoritarian adversarial democracy, constitutional changes can generally be made through simple legislation passed by Parliament. This, in effect, is what the Regulatory Standards Bill will do if it is passed into law. Current legislative guidelines give government the power of discretion. This bill will remove that discretion and give excessive powers to a proposed Regulatory Standards Board. The board will be made up of financial advisors, a group with a narrow focus of interest, and led by the Minister of Regulatory Standards. A new role currently held by David Seymour, the ACT Party leader and creator of this bill. That to me seems a conflict of interest, if ever there was one. Should this bill be passed into law, Network Waitangi Whangarei also fears for the future decisions of another government statutory body, the Waitangi Tribunal. The Waitangi Tribunal 2014 decision regarding Te Paparahi o Te Raki, the Y1040 claim, was as follows, and I quote, We have concluded that in February 1840, the rangatira who signed the treaty did not cede their sovereignty. That is, they did not cede their authority to make and enforce law over their people or their territories. Rather, they agreed to share power and authority with the governor. They agreed to a relationship, one in which they and Hobson were to be equal while having different roles and different spheres of influence. In essence, rangatira retained their authority over their hapu and territories, while Hobson was given authority to control Pākehā. End of quote. And despite the hours of evidence and research, the pouring through of historical documents and correspondence between the Home Office back in the 1830s in England and the tangata whenua and missionaries in Aotearoa Nuterini here, Paul Goldsmith, the current Minister of Treaty Settlements, doesn't accept the findings of the Waitangi Tribunal on the Y1040 claim. He is not willing to enter into a settlement with the iwi whānau Apanui due to a current agree to disagree clause on the sovereignty issue. It also inhibits the possibility of a settlement with Taraki Northland iwi Ngāpuhi, the area to which we belong. If this government can ignore this legally constituted statutory process under current legislation, it bodes poorly for the role and decisions of the Waitangi Tribunal if the Regulatory Standards Bill is passed into law. Paul Goldsmith says he believes in the sovereignty of Parliament, which he says is only a representation of the democratic will of the people of New Zealand. Paul Goldsmith would seem to be out of touch with the democratic will of the people. Recent research by O. Hellman in 2023 and recorded in a 2023 issue of Political Science, issue 75, on settler memory and Indigenous counter-memories and the narrative struggles over the history of colonization in Aotearoa, New Zealand. This shows that 70% of people who were born between the year 2000 and 2026, i.e. those who are now in their late teens and early 20s, see the Treaty of Waitangi as an important historical event. It also found that better understanding of the Treaty of Waitangi fostered greater unity and empathy between the people here of Aotearoa, New Zealand, which is contrary to the message from some of our politicians. The focus of this, however, if this bill was passed, it would seriously undermine that democratic will of the people of New Zealand, which Paul Goldsmith talks about. The focus of the decision-making in this bill is the financial concerns of a regulatory board of economists, prioritising so-called efficiency, individual liberty, and corporate property rights.
Catherine, I'll just get you to conclude your remarks. I'd like to give a question to Takata Ferris.
Okay, yeah. Currently, 50% of wealth of New Zealand is owned by 10% of the population, and it represents the interests of this 10%. So Network Waitangi, we see this as constitutional change by stealth under the guise of regulatory standards legislation, and we would urge any future governments to seriously explore current regulatory standards and the possibility of constitutional transformation only in consultation with the tangata whenua. Thank you.
Very good. Mr. Ferris, we've got 1 minute, so if we can just have a quick exchange, it'll be...
Yeah, kapai Cameron, thank you. Tēnā koe, Catherine, and thank you for your the long service in raising tiriti understanding in the country. And given your history as a tiriti educator, what's your assessment? What's your view, your assessment of the tiriti competency of the bill's primary sponsor and Deputy Prime Minister, David Seymour, in relation to this bill?
I I understand he whakapapas to Ngāti Rehia and Ngāti Rehia from up here in Kerikeri, Northland, Tiraki, state adamantly that he does not represent their point of view. So he is not representing a Māori constituency, a tangata whenua constituency.
Okay, we'll leave it at that. Thank you so much, Catherine, for your time and energy in your submission and presenting to us this afternoon.
Thank you.
Very good. Okay, Madam Clerk, have we got NZNO queued up? Oh, no. Yeah, no, we've got, yes, NZNO. Nurses Organisation?
Yep, they're here in the room.
Yep. Oh, very good. Very good. Have we got Kerry and Paul?
Correct.
Very good. Okay, you guys know the drill. We've got 10 minutes. It'll be good. I suspect members may have a question or two, so leave us that opportunity if you can. We look forward to it.
Thanks, Chair. Ko Paul Galta toku ingoa, ko o te tūmaki o te tuputanga tapui kaitiaki o Aotearoa. I'm Paul Galta and I'm the CEO of the Nurses Organisation.
Kia ora koutou katoa, ko Kerry Nuku toku ingoa, he kai whakahaere tōputanga tapuhi kaitiaki o Aotearoa.
We want to keep our submissions brief because we do want to get into the Q&A. I'm just going to do a few general comments. First of all, overall, we oppose the bill, and surprisingly, it ignores for us the place of Te Tiriti in Aotearoa, New Zealand, and so breaches it. We see it as promoting a supremacy of individual property-based rights over important collective rights. And thirdly, it is unnecessary and promotes a further regulatory load and bias. And other points have been made by other parties around these points. What I want to talk about briefly is the threat to our public health system that we see the bill posing. New Zealand's long had a public health system. While obviously, and it's well documented, it's under stress currently, there is a strong consensus we see across the country that for reasons of equity, accessibility, affordability and public health, this public health system should be continued and continually improved. A public health system is a collective right of all New Zealanders. The direction of the bill threatens the collective right by holding it secondary to the individual right. For example, the fluoridation debate is an example of that tension. Public health initiatives that protect communities will be held subject to the individual right to not be protected, even if this puts at risk the health of the community at large. That's clearly untenable in our society. Likewise, an individual property right to build and own a private hospital could be subject of compensation when a government, for perfectly good reasons, for example, equity, ceases to contract services to that private hospital, even when the private operator took on that risk in the first place and has priced it in. And I can assure you that nurses, even those working in private hospitals, do not accept that. Kerry.
Kia ora, Paul. As the kai whakahaere of tōputanga tapuhi kaitiaki o Aotearoa, I represent the voice and aspirations of Māori members, Te Runanga o Aotearoa, and am responsible for organising, progressing, advocating and actioning tikanga Māori. Māori nurses and healthcare assistants are in a unique position. They witness every day the inequities in the health sector, which make Māori more likely to suffer from preventable illnesses and comorbidities and lead them to shorter lives than non-Māori. Our people are dying already at a faster rate. Te Runanga have grave concerns the bill will continue to perpetuate these health inequities. In an attempt by ACT Party to expunge history and the intergenerational trauma of Māori, which has left many fearing the traditional health sector. That fear and mistrust of doctors and hospitals has resulted in Māori being more likely to suffer from health conditions and chronic diseases, including diabetes, asthma, heart disease and lung cancer. They are less likely to have been immunised and more likely to die from suicide. Māori are also more likely to face the barriers to accessing health care and to have experienced discrimination in the health system. These stats are a national shame. Evidence and history tells us that Māori and iwi-led health services are key to improving health outcomes for Māori. We saw during COVID pandemic a significant improvement in Māori immunisation rates once iwi providers were able to offer a kaupapa Māori whānau-centred vaccination services. These services were enabled because of considerations by policymakers of Te Tiriti of Waitangi. NZEI acknowledges that the pre-existing rights of Māori as tangata whenua and Te Tiriti of Waitangi as the founding document in Aotearoa, New Zealand. Te Tiriti provides a foundation to help fix the serious and dire health problems faced by Māori. It's because it pushes law and regulation makers to ensure Māori have the same access to opportunities as non-Māori and fully participate in decisions which affect them and to have their voices heard. The Regulatory Standards Bill will remove the Crown's obligation to Te Tiriti of Waitangi and silence the voice of Māori in decision-making in health. This has deadly consequences. It will undermine the principles of equity and justice for Māori. It will perpetuate colonial structures of power and control over Māori communities. This bill is contrary to the government's legislated aim for healthcare provisions, the 2022 Pai Ora Healthy Futures Act, which includes ensuring Māori and other population groups have access to services in proportion to their health needs, and that the health sector should take measures to protect and improve health and well-being. Tangata whenua have faced generations of systemic racism in the health sector. This means they are less likely to seek medical care when they are sick and more likely to drop out of the health system altogether. The Regulatory Standards Bill will leave a legacy for ACT leader David Seymour. That legacy will be that Māori will remain sicker than other New Zealanders. They will continue to die at a faster rate than non-Māori, and this is devastating for our whānau. We urge the Health Select Committee to recommend Parliament vote this bill down at its next reading. Kia ora.
Thank you.
Very good. Okay. Members, questions for the New Zealand Nurses Association? For Paul and Kerry, I'm going to go to Takata Ferris.
Tēnā kōrua. Given your history and work in the health space and the health equity lens, who in your view stands to be most significantly impacted, negatively impacted, in terms of health equity by this bill?
There is no doubt Māori will be most negatively impacted, and as I said in my statement, will continue to die at a faster rate when their voices are silenced from this piece of legislation.
Can you perhaps just give us your view on how Te Tiriti o Waitangi might actually provide for improved health outcomes for Māori?
If we were truly to implement Te Tiriti of Waitangi as intended, any piece of legislation, any consideration of change should include Māori being at that table of decision. There should be equity in terms of shared governance, shared responsibility and shared funding to reduce and improve those inequities that currently exist. We are battling at the moment for those nurses that work within Māori and iwi provider sectors to be recognised the same as their colleagues that work within hospital. This has been over many, many years and we still haven't achieved that. So truly to embed a Te Tiriti approach will include having people at the table and resourcing it adequately.
Tēnā kōrua.
Okay, very good. We're at time. Thank you, Paul and Kerry from the New Zealand Nurses Organisation, and we appreciate you coming into Parliament this afternoon and making your submission and your additional comments.
Thanks, Cameron.
Thank you. All the best. Okay, that takes us to an individual submission. Have we got Tohei Ashby queued up, Madam Clerk? Oh, very, very good. Let's get you on the big screen. This looks like it's going to be worth seeing. Let's have a look. Okay. Anyway, Mr. Ashby, as we do that, welcome. Thank you for your patience this afternoon. We look forward to your 5 minutes. If you want a potential dialogue with some of our members here, leave us a little bit of time at the end.
Ora. Tēnā rā koutou katoa. Tēnei kei te mihe tū rā, tēnei kia koutou katoa tiro mai nei I roto tēnei pukumata I te rā, tēnei ai ei. Nō reira e tino mihe tūna tēnei kia koutou, ngā kai whakawā, tēnā koutou. Tēnā koutou. Ko tohe ahi pītaku ingoa, nō roto o Ngāti Hine, Ngāti Rahiri, Ngāti Kau. I roto tēnā, ki au e tautoko ana tēnei pire ke mui a tātou, mua ta tātou aroro. E kore au e whakaa ke tāka heka hini a tātou I tēnei kāwana tanga ke rungi a tātou te wimā. I roto tēnā ka mea te kāwana ke a rātu ta tātou tino rangatiratanga. Ka hori. Ke a rātu ta rātou tino rangatira mo te iwi pākea. O ta mātou tino rangatiratanga kei raro te wakaputanga me te tiriti o waitanga. Ko taku tupuna te ingo taku tupuna ko te pene I haunangia te tiriti o waitanga. Koe tēnei tona ingo. Koe tēnei te take kaukahau e tautokona tēnei pire ke mua ta tātou aro. Ka puta ki tahi ngā kōrero a taku tupuna I te mutunga o ta pakanga o te nota, ko taku tupuna a kauiti. E te whānau, takahia te ririki raro o koutou wau e kau ki te whakapono. Ne kore he poi pākea koutou a muri akeni. Tāria ke kakaiti te namu o te whārangi o te pukapuka e kōrero na tēnei mo te tiriti o waitanga. Tatari ke kakaiti te namu o te whārangi o te pukapuka reira ka tahuri atu. Ke reira ka tahuri atu e. Kaua takahia ngā papaponu o mātu o tupuna. Titiro ki te taumata ta mana, kei reira te oranga mo tātou. Ka tiro tātou e hakena a rātou I tāwahi. Ka kite tātou ngā pakanga nei wa tātou motu o tā rātou tino rangatiratanga. No reira ata tiro hia, wera kōrero I wahomau aku tupuna ki a tātou te kāinga. No reira koe tēnei taku kōrero mutunga, e kōrero ana hau mō ngā tangata I tuhia tēnei pire. I kitea, ki ei kitea. I rongo, ki ei rongo. I kōrero hia, ki ei kōrero hia. Nā koe tēnei waku kōrero. Ko oti ke au te tuku waku kōrero ki te pāramata, e runga ngā pepa wehatu wera ki koe kona, ko ngā kōrero I hi au ke te tuku atu kia koutou, e pāna ki tēnei pire, ke mua ta tātou aro. No reira tēnā koutou.
Oh, very good. Thank you, Mr. Ashby. Have we got any comments or questions, members?
Kia ora, Cameron.
Oh, kia ora. Takaru Ferris.
Tēnā koe tohe. Mō nei e tohe nei te tohe roa. Kia mōhio mai koe aku tamariki he uri no matauri. Ako tō rātou tibuna pāpā nau epi hā tērā te tāwharau I a rātou. No reira, he tika tau, kei te kita atu I te kore whakarongo, I te kore tuhi, te kore tahuri mai, a te kāwanatanga ki ngā tikanga I o hā ki tia mai roto I te whakaputanga o ti rā te tiriti o Waitangi. No reira, ki o whakaro me pēhea rā tō tātou whakahoki atu a te iwi Māori. Me pēhe te whakautu a te iwi Māori ki tēnei mahi, e mahingia nei tēnei kāwanatanga, Aotearoa.
E pēne kena waku kōro, ko taiki te wā ke huri wa tātou tuara, I tēnei kāwana, e tūkino nei a tātou. Ka hoki tātou ki te wakaputanga, ko e tērā taku hehia. I te mea, e kore rātou I rongo, te timatanga o te hainanga, te tiriti o Waitangi, leira ka timata te tūkinotanga ki runga I a tātou. Tātou ki tēnei wā, e tūkino tonu nei ki a tātou.
Okay.
Tēnā koe pā.
Oh, very good. I can only hope that you were saying nice things about the government, given the lack of te reo I have. But lovely to see you, Mr. Ashby. Thank you for your contribution, your submission, and all the best for the rest of the day. Tēnā koe. Okay, members. That as we wind up, I think we've got 5 or 6 left. We go to an individual submission by Mr. Raymond Bishop, who I understand is queued up. Raymond?
Yes.
Tēnā koe.
Tēnā koe. Okay, 5 minutes. We'd love to hear your contribution. We're saving the best till last, so we look forward to it.
Kia ora. Ka pai ki te timata.
Thank you.
A tuatahi mihi whakawhetai ki te io. Mea no te ariki nui kuini nā waihone i te pō, me te wharekau i ariki. A rire hau, ai mārire. Kia tātou e tūpuna i te tua te arai. Ko taia tēnei ki pito i tēnei ki rā ki te whāriki ana. Te whakaaro mō tātou katoa. Ka korirotia mai te tua papa o te tika me te pono me te aroha. Anō reira. The Regulatory Standards Bill, or the RSB, proposed by the ACT Party, will impact us as tangata whenua and other cultures affected by colonization, like our Scottish and Irish whanaunga. For example, living here in Aotearoa, who call New Zealand home. The RSB presents a nuanced understanding of the historical, legal, and social contexts of this country, and it will further diminish the dreams and aspirations you, my tupuna, had envisaged would be honoured in the treaty with Queen Victoria of England in 1840. The treaty, aroha mai. The Treaty of Waitangi is foundational to New Zealand's legal and social framework, recognising the right of tangata whenua as the Indigenous people. If the regulatory bill fails to adequately reference or uphold the principles of the treaty, it could undermine our rights and interests. The proposed bill by the ACT Party does not incorporate our customs and practices. That includes our environmental stewardship and will lead to the erosion of not only te wao nui o tāne, but the very soil beneath our feet, as the British royal family's doctrine of discovery desired from the beginning. David Seymour's RSB lacks consultation and consideration. However, this is consistent with previous governments who have promised the world and never delivered. Ignoring the treaty and regulatory frameworks could exacerbate tensions between tangata whenua and other communities, undermining the goal of social cohesion. Here in Aotearoa, and it is vital for the government to foster an inclusive approach that respects all cultures and their perspectives. Because this Act Bill does not align with the treaty, it will be legally challenged on a number of fronts, leading to costly and lengthy litigation, with some claims like Y894, which is still to be resolved as an example, and will create uncertainty for businesses and the sectors that hinder economic development of our great country. Not prioritising the treaty's principles in legislation can have long-lasting effects for future generations. The failure to recognise tangata whenua rights today could lead to ongoing struggles for recognition and justice of our communities in the future. The passage of the bill that neglects the treaty could set a concerning precedent for future legislation, potentially leading to a trend of sidelining tangata whenua rights in favour of expedient regulatory measures. In conclusion, Noki Tuapuna, if David Seymour and his Act One Way and Do Something Else Party believe that they can neglect the mana and the manner in which you all signed the Treaty of Waitangi, I sit here proudly opposed to this bill to uphold your rangatiratanga that was never adhered to with tika, pono and aroha as originally intended from our side, rather than the loss of land, health, language and culture that we have had to fight for in circumstances such as this brief mihi to you all. E whawhai tonu mātou, mo aki tonu atu, tū rau, tokoroa. Tēnā tātou.
Oh, very good. Thank you, Mr. Bishop. I can't see any hands in the air, so we'll take that as well understood. Thank you for taking the time today and making your point clear. And thank you for your patience and all the best for the rest of the night.
Thank you very much. Ngā mihi o te wā kia koe.
Kia ora. Right, that takes us to my hometown of Hawera by the look of it, because the sun's always shining in Hawera. Nati Ruanui. As our friends here will tell you, there's plenty of brewers on the Nati Ruanui iwi register, and there's plenty, and there's a few tenants there too. So look forward to your presentation.
Oh, well, thank you, Cameron. We'll just start with the karakia this afternoon.
Tēnā tātou katoa, karakia tīmata, ko te mauri e runga, ko te mauri e raro, ko te mauri e tamanui te rā, ko te mauri e papatūnuku. He mauri a atua, he mauri whenua, he mauri tangata, he mauri tū, te hei mauri ora. Tēnā tātou.
Kia ora.
Thanks, Cameron, and it's good to know that you are a Hara descendant, and good to see you here this afternoon. Look, Nati Ruanui acknowledges the opportunity to speak to our submission on the Regulatory Standards Bill. Nati Ruanui also acknowledges the importance of good and efficient legislation. However, Nati Ruanui is opposed to the Regulatory Standards Bill as presented. We don't say this from a point of criticism of this bill in isolation. Based on a long and detailed involvement and partnership with successive governments over the last 20 years in developing strategies, regulations, and draft legislation. Most notably, Nati Ruanui is an active participant in providing advice to the then Minister on the EEZ legislation, and more recently invited to be part of the development of offshore renewable energy legislation and regulations. Our expertise was acknowledged in the Commission's publication of best practice guidelines for engagement with Māori. In our submissions, we summarise from our point of view what this bill is attempting to do and its construct. We won't repeat these here, as I'm sure you've heard these several times today and in the days coming, I suspect. What we would say is Nati Ruanui is alarmed that this bill is built upon an ideology that is intended to promote individual property rights, constrain regulatory powers, and reduce the government's ability to implement environmental protections, social safeguards, and Tiriti-based principles. The proposed bill is a direct attack on Māori rights and interests and Tiriti principles. This in turn is a direct attack on Nati Ruanui. The principles as contained within the bill are largely being picked from an ideological neoliberal value political agenda and from the failed attempts of previous bills, which I understand there have been many. We consider they are racist and unfit for purpose. We have serious concerns about the limited exposure of this bill to wider communities. Overall, we consider engagement, feedback, and consultation to date to be completely inadequate. Where feedback was provided on the discussion document, none of the critical feedback has been taken into account when presenting this bill to Parliament. Nati Ruanui believes Aotearoa has already achieved a good, not perfect, standard of regulatory discipline. In most cases, well-developed and crafted statutes. While we may not always agree with the content and structure of these statutes, the clarity and purpose of legislation drafted at least over the last 20 years has been focused and bespoke to deal with our unique constitutional arrangements encompassing Tiriti commitments. We note that the current constitutional guardrails are already in place to ensure the best possible outcomes for Parliament to have confidence in the current management and development of legislation. And we note the regulatory impact statements, Legislative Design Advisory Committee guidelines, the Legislation Act, Parliament's courts, and of course the Waitangi Tribunal. And we set these out in more detail in our submission. The ideological shift of this bill constraining how legislation is developed and applied both in future and retrospectively threatens the very partnership of sovereignty, Crown and Māori, developed through Parliament, the Waitangi Tribunal and the courts. Good legislation and regulatory development are best achieved through partnership. The concept of partnership is a key principle of Tiriti, and in recent years, the green shoots of this has seen better and more robust outcomes when applied. We consider a careful collaboration partnership with the Crown as the unique outcome of Aotearoa's governance. The bill does not include any principle related to Te Riti. What a shame. We consider this a deliberate attempt to limit, if not exclude, the role of Te Riti as part of the legislative lawmaking process and potentially iwi, hapu and whānau engagement and partnerships. The ideological position of the proposed bill, along with the now failed treaty principle bill, is a shameful position taken by the government. Te Riti is the constitutional foundation of Aotearoa and must be enshrined in legislation and resulting regulation. Legislation is often the only backstop mana whenua can rely upon to ensure our rights are guaranteed and the outcome of Te Riti are managed correctly. The importance of these backstops is evident in the Resource Management Act and the Conservation Act, which has been around since 1987. Equally, concepts such as environmental precautionary positions adopted in the EZ legislation and subsequent interpretation of the Supreme Court support the rightful place of Te Riti within the governance framework we operate in. The Crown has an overall obligation to ensure legislation and regulation gives effect to Te Riti and the articles set out. Silence of the proposed bill on what this constitutional important point provides no certainty to mana whenua and leaves a huge area of overall uncertainty. In fact, this point is likely to undermine the ideological position of this bill in that it will create more layers of complexity and judicial challenge as both Parliament officials and the courts grapple with the absence of well-founded and agreed Te Riti principles. The absence of Te Riti principles also removes obligations for the executive branch of government and ministers to consider Te Riti in decision-making. Ministers could not be held to account under this proposal. At best, Te Riti obligations could be no more than a simple policy consultation exercise, which could then be ignored when legislation is drafted. We consider there is a current obligation under Te Riti, Articles 2 and 3, to promote and achieve equity for Māori, especially where there is a disparity of outcomes and deliverable of services. Healthcare, which we've already heard this afternoon, is a clear example of this disparity. Overall, Nati Ruanui believes this bill is in breach of our Settlement Act and that there is a clear duty of the Crown to engage and discuss such proposals directly with us. This lack of good faith underlines our concerns with the passage of this bill and the commitment given to the bill through the coalition agreement. Further, any legislation drafted should be robust enough to enable clear interpretation of application. This legislation can only work through additional guidelines issued by the minister and reflects poor practice. This approach provides no checks or balances on ministerial power, and such an approach should be rejected. The establishment of a regulatory standards board undermines, if not attempts to remove, the role of courts to interpret and set precedent of our legislative process. We acknowledge the statements that the board is complementary to the court process, but this is equally confusing and represents poor design thinking on behalf of the government. Nati Ruanui strongly opposes the use of a board framework as set out in the bill. Nati Ruanui does not agree the approach should reach back into legislation and apply this new regulatory framework. In effect, the regulatory power of the minister could be used to transform legislation on a scale never seen before. There has been no logical case put forward to us to warrant such a wide sweep of power, and further, the provision of regulation to provide more detail on how this review and stocktake is to be undertaken is alarming given regulation lacks public scrutiny. Powers of the Minister of Regulation to initiate regulatory reviews, providing the Ministry of Regulation through the Chief Executive to require information to be provided is regarded as an extreme overreach of executive power. The Regulatory Standards Bill appears to be an attempt to enact an agenda that prioritises the rights and profits of individuals and corporations over the collective rights of a wider good of communities. We recommend that the Select Committee return this bill to Parliament unsupported. Thank you, Mr. Chair.
Thank you, Mr. Young. very clear. I'm going to go to Marama Davidson for a quick question.
I apologise for my technology. Firstly, can people hear me?
Yes.
Thank you very much. Tēnā korua, tēnā koutou o Nati Ruanui. It was wonderful to hear your submission. Thank you. I'm not surprised that you state that your expertise was acknowledged. Ngāti Ruanui expertise was acknowledged in a best practice guidelines for engagement with Māori. Would you care to give the committee an example of those practical best practice ways of engaging with Māori that you feel this bill would get in the way of?
Oh, this bill rules out all possibility of engaging with Māori, and where engagement does occur, this bill allows the government or the executive branch of government to then ignore it when drafting. So when we've seen active cooperation, and I must say one of the most active cooperations we've seen is through a national government with the EZ legislation, where we were treated as a partner in helping draft that. That was a true partnership. This is where the essence of what we were talking about in the best practice guidelines came to fruition. We don't see any evidence of this being able to be enacted through this new legislation by effectively ignoring us as Māori and ignoring our contribution. It allows the executive to stop with consultation and not take us any further and ignore us.
Thank you. Thank you, gentlemen. A small but historically very important and proud iwi, Nati Ruanui, and thank you, Graham, for all your leadership over a number of decades now, despite your youthful looks, both at a municipal level and at a iwi level. So thank you for that. We appreciate your ongoing engagement with Parliament, and we look forward to another submission another day, but we appreciate you both attending.
Thank you, Mr. Chair.
Thank you. Okay, members, that takes us to Dr. Rebecca Graham, Co-Chair of Access Matters Aotearoa.
Kia ora.
Kia ora.
We good to go?
We are good to go. I like the professional backdrop. That's very good.
Thank you.
I hope it's real. I hope it's not one of these AI things.
No, I spent some time while I was waiting creating a bespoke backdrop just for today. So
well, you're keeping that plant well watered. It looks good. Okay, we look forward to your 10-minute presentation, Dr. Graham.
Thank you very much for having me here. I'm presenting on behalf of Access Matters Aotearoa. Access Matters has a very passionate group of workers and a large range of supporters who are really keen for all areas of public life to be accessible for everyone. When we talk about access and accessibility, we're referring to our ability to engage with and belong to the world around us. When people get denied access, we call that a barrier. And everyday barriers that a lot of disabled people face include obstacles when getting around, being able to get into buildings, being able to get into public buildings, crossing the road safely, and accessible public transport. But it also includes information and communication barriers like inaccessible websites, apps, signage, printed materials, a lack of closed captioning. The existing legislation we have here in New Zealand does not provide enough guidance to organisations on how to do things like design a website, provide employment, deliver goods and services in a way that everyone can access. At Access Matters Aotearoa, we want to implement ways to address accessibility issues using legislation with clear standards that are enforceable and that lift the accessibility across the country. Creating good legislation for us means creating standards and policies that support accessibility and embed it across a range of areas. The Regulatory Standards Bill in its current form risks entrenching barriers for disabled people and undermining New Zealand's human rights obligations, particularly with regard to the United Nations Convention on the Rights of Persons with Disabilities. We have summarised these risks into 5 key areas. Firstly, socioeconomic rights for disabled people. This bill prioritises reducing regulatory burden in economic terms, but for disabled people and their families, good regulation is often what enables their basic human rights to be met.
This includes basic rights such as access to housing, inclusive education, transportation, and being able to access public services. Article 19, which is the right to live independently and be included in the community. Article 24, which is the right to inclusive education. And Article 28, which is the right to an adequate standard of living and social protection of the UNCRP, cannot be upheld without the appropriate regulatory protections and investment. Under this bill, these really necessary policy interventions are too easily dismissed, which creates a regulatory chill which discourages inclusive practices. Number two, equity measures are in the firing line. This framework created by the bill really does not address equity promoting regulations such as anti-discrimination laws or the implementation of accessibility standards. And where governments are interested in implementing such laws, the regulatory standards bill creates additional layers of red tape, and it means these laws are vulnerable to repeal. This is a contradiction of Article 4 of the UNCRPD. Number three, accessibility now becomes even more at risk and even harder to achieve. New Zealand currently does not have mandatory enforceable accessibility standards across most sectors. There's one exception, that is the NZS 4121/2001, which is our building accessibility standard. This is 20 years old. It's long overdue for revision. Despite repeated calls from disabled people and allies, the standard has remained unchanged, and the ministry responsible for it has not yet taken steps to update it. Without this kind of regulatory approach, inaccessible built environments persist. Number four, the erosion of non-discrimination protections. Article 5, equality and non-discrimination, prohibits discrimination and demands equal protection for disabled people under the law. But under this bill, rights-based regulations are able to be easily sidelined in favour of economic reasons and so-called cost efficiencies. Current protections in areas like education, employment, housing, and access to public services could be diluted or removed if their enforcement is deemed too costly. We cannot let human rights be traded away. Our human rights obligations to each other are not regulatory burdens. They are part and parcel of creating a healthy, fully functioning society. Number five, reduced voice and participation. This bill reduces opportunities for marginalised and minoritised groups, and especially disabled people, to shape the policies and the legislations that impact on their lives. Article 19, the right to live independently and be included in the community. Article 21, the right to freedom of expression and access to information. And Article 28, the right to an adequate standard of living and social protection from the UNCRP, all affirm really strongly the right of disabled people to be involved in decision-making in areas that affect them. Processes like co-design and consultation with disabled people are not bureaucratic red tape. They're democratic imperatives, not efficiencies. They help create better laws and shape policies in ways that mean they can work to achieve what is intended. Lastly, in response to some suggestions across the last 4 days that this bill won't stop the government from making laws as it's not legally blinding, we do want to note the chilling effect of the takings clause, which will work to prevent the government of the day from making certain laws because of the potential expense of compensation claims. This is directly relevant and has direct consequences for accessibility-related legislation. The RSB also puts at risk the legal rights disabled people currently have because of the retrospective nature of the bill. In response to an assertion that the bill won't affect people's human rights, we would like to note from Access Matters Aotearoa the response of the Human Rights Commission, which strongly disagrees with this assertion. The Human Rights Commission is a single accredited national human rights institution for New Zealand and has the role of advising the government on human rights. They have stated that there can be no way this bill can be said to be genuinely consistent with New Zealand's international human rights obligations, nor the Bill of Rights Act. and that many of the substantive rights gains that people currently enjoy on an everyday basis are the result of laws which have balanced an array of considerations. Such laws may treat people differently, limit certain liberties, and may not withstand a very narrow cost-benefit analysis. In conclusion, Access Matters Aotearoa urges the committee to reject this bill. If we must have regulatory standards, we need standards that explicitly protect accessibility, equity, and inclusive participation. Regulatory quality needs to be measured by whether it upholds human rights, advances social equity, and includes diverse voices in decision-making. Thank you. Kia ora.
Thank you very much, Dr. Graham. We're almost at time, but I've got a quick question, I'm sure, from Dr. Deborah Russell.
Oh, kia ora, Rebecca. Great to hear your submission. Just listening to this, it struck me that, disabled people are often effectively excluded from citizenship, and this bill will make that worse. Is that your view?
Very much so, very much so. It's hard enough already. We're working really hard to improve accessibility, and this bill just kind of takes a giant sledgehammer and says, nah, we're not going to do that, and it's horrendous. Yeah, really potentially very bad.
Okay, thank you.
Okay, thank you, Dr. Russell. Thank you, Dr. Graham, for your presentation. You obviously got the memo that don't give the politicians after 4 o'clock any more than 5 clear points, and that they came across very clearly, so thank you.
Yeah.
Okay, that takes us to the New Zealand Law Students Association. Dr. Glass, have we got them queued up?
Yes, they're online now.
Oh, very good. Okay, team, we've got 10 minutes for you. Thank you for your patience. We look forward to your submission. If you want a little bit of dialogue potentially with MPs, I encourage you to leave a little bit of time at the end.
Awesome. Thank you so much. First of all, kia ora, and thank you to the Finance and Expenditure Subcommittee for allowing us to speak today. By way of introduction, my name's Angelica, and I'm the Education Vice President of the New Zealand Law Students Association. We are a group who provide advocacy and a united voice for matters affecting law students across the country. So I'm here alongside Vivian and Maha today, law students and members of our submissions committee, to present our views on the bill. So to start off, the New Zealand Law Students Association strongly opposes the bill as it fails to uphold core constitutional principles, marginalises Māori perspectives, and undermines equity and good lawmaking. Our submission in sum will highlight that te tiriti and of the concerns regarding te tiriti and tikanga inclusion, minority and equitable impacts of the bill, democratic processes failings, as well as the failure of good lawmaking. So I hand over to Maha to discuss the formal 2 points.
Kia ora, ko Maha Whia Toku Ingoa. I'm a final year law student at Waipapa Taumataro and also sit on the executive for the New Zealand Law Students Association 2025. Thank you for having me. My first submission on behalf of NZLSA is in regards to our concerns for te tiriti o Waitangi and tikanga Māori according to the bill. So throughout law school, it's an integral part of our learning to understand that te tiriti o Waitangi is a fundamental part of Aotearoa's constitutional law, which should inform the processes we undertake within our legal system. These learnings provide a basis for how Kiwi lawyers should argue and reason, especially in the 21st century. These teachings are not progressive politics. Te tiriti o Waitangi is part of our current law, whether we like it or not. And the bill's silence on te tiriti o Waitangi to prioritise individual liberty constitutes a fundamental breach of the Crown's obligations and risks setting a dangerous precedent for how future legislation is drafted and evaluated. NZLSA notes the lack of meaningful consultation given to Māori during this bill's drafting and the lack of co-design mechanisms in treaty impact assessment requirements, among other injustices during this bill's process. If the future of law in Aotearoa is to be genuinely just, it must rest on a foundation that affirms te tiriti o Waitangi as central to our constitutional identity. This bill moves further away from this vision, retreating into a monocultural legal framework that prioritizes economic individualism at the expense of constitutional partnership.
NZLSA reiterates that this is not how good lawyers or good lawmakers reason when implementing or interpreting legislation. In fact, we are also strong supporters of the implementation of a compulsory tikanga Māori course within our legal education, and the NZLSA Education and Wellbeing Survey 2025 showcases that the majority of law students support this too. And why is this? Tikanga Māori is taught to us to be the first law of Aotearoa New Zealand. It reflects a worldview grounded not in individualism or linear efficiency, as showcased within the principles of this bill, but in relationships, reciprocity, balance, and collective well-being. There has been growing recognition across the courts that tikanga Māori is not simply a cultural background to law, but is law in itself. The complete absence of tikanga Māori in the bill reflects not only a missed opportunity, but a deliberate narrowing of what constitutes as legitimate knowledge and legal value in Aotearoa. The principles presented within this bill do not reflect the direction Aotearoa is moving towards, but attempts to reassert a singular legal narrative that is out of step of Aotearoa's pluralistic constitutional evolution. NZLSA's second submission relates to this bill's minority and equity impacts. Another thing we learn within law school is a difference between formal legal equality and substantive legal equality when interpreting the rule of law. The bill's emphasis on formal legal equality, presenting every person as equal before the law, fails to recognize that equity and justice in the New Zealand context cannot be achieved by treating everyone the same. Something NZLSA is particularly concerned about is that this bill's regulation review framework enables the potential removal or dismissal of targeted legislative measures specifically designed to address systemic inequalities affecting women, people who are disabled, Māori, Pacifica, Asians, children, rainbow community, among others who are already disadvantaged within our legal system. There's also ambiguity in just how far-reaching this bill actually is. For example, within our law schools, targeted schemes, especially ones that focus on uplifting our Māori and Pacifica tauira, are vital for the development of our law and legal profession. Such measures are crucial to ensuring that diverse voices are present, supported, and empowered, which is an essential foundation for delivering sound legal advice that reflects the diversity of Aotearoa New Zealand. These are measures that recognize and respond to the historic and ongoing disadvantages that many of Aotearoa's law students and their communities face. The principles found within this bill could overlook this reality. This bill risks dismantling various tools needed to achieve substantive equality and threatens to undo decades of progress towards inclusive legal representation. I want to finish with saying that Aotearoa's law students are diverse. They are the now and the future of the law, and also the future of the select committee you currently sit on. And it's baffling to even attempt to concise their interpretation of the law to a view of a party that received only 8% of the vote. I now pass on to Vivian to finish our submission.
I'm Vivian Bunquin, a fifth-year law and arts student at the University of Auckland, and this is my second year as a member of the New Zealand Law Students Association Submissions Subcommittee. I want to highlight serious concerns we have about the democratic process and lawmaking standards concerning the proposed bill. I start with the public consultation process. During the initial round of public consultations, 22,000 responses were received. An overwhelming 88% of those submissions opposed this bill. Notably, all categories of submitters, individuals, sector groups, community organizations strongly opposed it. Even industry and sector groups, which recorded the highest level of support, only backed the bill by 12%. A bill that receives such a unanimous public rejection should not move forward. Many saw the bill as creating a problem where none exists, overcomplicating our legislative framework and risking vested power in an overly politicized regulatory standards board that fails to respect Te Reo Waitangi. These issues were not substantively addressed in its legislative drafting. Worse still, the language of the bill has been vague from the outset. The initial consultation document asks submitters about what the bill should aim to do, denies submitters a concrete draft of the bill to critique. Public consultation merely relied on interim statements with ambiguous language, which stifle their ability to give constructive feedback. Compliance with a democratic lawmaking process must be assessed against the manner of public consultation and how the final version of the bill responds to this public feedback. We submit that so far the Regulatory Standards Bill has failed on both accounts. Parliament derives its legitimacy from the public. Ignoring these concerns is fundamentally undemocratic when public opposition is this strong. I turn to the next issue of good lawmaking standards. At its core, this bill contradicts democratic principles. The bill elevates property rights to a status near equal to universal human rights guaranteed by the New Zealand Bill of Rights Act. The NZ Board deliberately does not protect propriety rights because they are, by their nature, exclusionary. As such, propriety rights should not outweigh principles like equality, public safety, or the protections guaranteed by Te Tiriti. And under the bill, legislation impairing these propriety rights could make the government liable to pay significant compensation. The result is shifting costs away from corporations and onto the taxpayer, undermining our collective understandings of social responsibility. The bill creates more bureaucracy despite its claim to minimize administrative burdens. It proposes a new Regulatory Standards Board appointed by the Minister of Regulation to assess current and future legislation against its narrow principles. These additional processes can delay essential enforcement of public protections like building regulations or environmental standards. This board also does not reflect our constitutional values or commitment to Tiriti o Waitangi. Unlike the Waitangi Tribunal, whose mandate is rooted in the treaty principles and the text of the treaty, the board would be politically driven with no grounding in Aotearoa's constitutional traditions. In short, this process has failed the public interest, failed robust lawmaking standards, and failed to uphold the principles of democracy. If the majority is firmly expressed that the current system of regulation does not need amendment in this way, we have to listen. Legislation serves the public interest and does not override it. In conclusion, New Zealand Law Student Association strongly opposes the proposed bill. It has to fail. Kia ora.
Okay, thank you very much, Angelica and team. We're over time, so we won't go for questions, but we appreciate your presentation and your submission, and keep engaged with the process and with other legislation as it comes through Finance and Expenditure Committee and other committees as well. Dr. Duncan Webb, he was once a law student, and it only seems like yesterday, doesn't it, with Dr. Webb? And he's giving you a wave of gratitude.
I'm trying to. I need to redo the gallery.
Duncan can give the vote of thanks. Duncan, Dr. Duncan can give the vote of thanks.
Keep up the good work. Great to see law students contributing like that. Really valuable. Awesome.
Kia ora. Thank you.
Okay.
So much.
Hey, thank you so much. Thanks, Angelica. Thank you, team. Okay. Right. That takes us to the Tauranga Māori Business Association. Who have we got?
Tēnā
queued up
koutou,
there?
katoa.
Oh, kia ora, Jackie.
Kia ora.
Thank you for your patience. We're looking forward to your presentation. We're running 2 minutes late, which is pretty good at the end of the day, and so we look forward to your 10 minutes.
Bye-bye. Ko Jackie Rolliston Steve tōku ingoa. I'm presenting online today on behalf of the members of the Tauranga Māori Business Association, and in lieu of our chair, Leonie Whakua, who unfortunately was unable to speak today. Ngā mihi nui ki a koutou for the opportunity to present our views on the Regulatory Standards Bill. The Tauranga Māori Business Association represents a diverse membership of Pākehī Māori in Tauranga Moana, business owners who whakapapa te Nati Ruanui, Ngāi Te Rangi, Ngāti Pukenga, and others who've made this rohi their home. Our members work across industries like construction, agriculture, professional services, tourism and real estate, as well as a raft of smaller scale Pākehī who are using their own innovative and creative talents to not scale up, but to live and love their day-to-day mahi while supporting their whānau. Together we are united on our strong opposition of the Regulatory Standards Bill. This bill risks doing real harm to Māori businesses, and we believe it undermines the foundations of Te Tiriti o Waitangi and tikanga Māori in both principle and practice. We do want to acknowledge, however, that we share the bill's aspiration to improve the quality, clarity and consistency of regulation in Aotearoa, but we believe this can only be achieved in genuine partnership with Māori, upholding te tiriti o Waitangi and recognising tikanga Māori as part of our legal and cultural fabric. The reasons for our submission is as follows. Tuatahi, breach of te tiriti o Waitangi. The bill was introduced without consultation with Māori, with no reference to te tiriti o Waitangi and no consideration of the Crown's constitutional obligations as a treaty partner. By omitting te tiriti, the bill ignores the basis on which Māori participate in business and governance in Aotearoa. The mechanism it proposes could be used to dismantle or legally challenge co-governance frameworks, resource settlements, and other tikanga-based models that are essential to Māori enterprise. Tuarua, misalignment with Māori business realities. The bill proposes a set of regulatory principles grounded in Western individualism, such as freedom of contract and individual property rights. These might appear neutral on paper, but in practice they create barriers for Māori businesses operating within collective and tikanga-based models. Let me just illustrate this with a couple of comparisons. Bill principle, freedom of contract. Collective agreements, tikanga obligations, and whānau-based decision-making are the norm for Māori business reality. Bill principle, individual property rights. Māori business reality. Land and assets are commonly held in collective Māori title or trust structures. Bill principle, less restrictive regulation. Māori business reality. Tikanga-based practices often go beyond regulatory minimums by design for kaitiakitanga. Minimising barriers to entry. The Māori business reality is that Māori-specific mechanisms, for example, settlement redress, marae-based governance, may appear restrictive, but they're essential. Bill principle, one-size-fits-all approach. Māori business reality. Māori businesses are culturally and regionally specific, requiring flexibility. And finally, the bill principle around having no mention of te tiriti or tikanga Māori, yet these are the foundations of Māori economic and constitutional participation. So these comparisons illustrates the problem at heart of the bill. It assumes that all businesses operate in the same way, under the same rules, but Pākehī Māori exist because of and in accordance with te tiriti and tikanga. Regulatory standards that ignore this not only exclude us actively, but undermine our ability to participate and to thrive. Tuatoru, practical impact. We're not speaking in theory. For example, a marae-based business that provides catering and events on ancestral land, employing whānau and observing tikanga around food, land use and profit sharing could be challenged under a system that values only individual property and profit motives. A Māori land trust managing whenua for housing and horticulture under kaitiaki principles could find its approach deemed inconsistent with regulatory norms that exclude collective or tikanga-based decision-making. One of our business members, a Māori-owned construction company building papakainga, whānau homes and marae facilities, their business isn't just about contract and profit. It's a kaupapa to keep whānau connected to their whenua and ensuring that tikanga is upheld throughout the build process. This bill risks treating their way of working, collective, culturally grounded, long-term focused, as non-compliant, simply because it doesn't fit the Western business mould. If I may, I'd like to channel the words of wisdom of my Auntie Mabel, one of our well-known whanaungi here in Tauranga Moana, because she's got a good way of cutting through big words and saying what everyone in the whānau already knows in a way that speaks to all of us. And she's already walked the hard path of being a successful, unapologetic Māori voice in a world that often expects us to leave our culture at the door. She'd say, "E te whānau, what is this bill really saying is that Māori need to fit into Pākehā ways of doing business or else. That we should act like little one-man bands, chasing the dollar, thinking only of ourselves. But that's not who we are, and that's not how businesses work. Take my cousin down the road. She runs a small whānau-owned cafe on the marae. Everyone in the whānau works there. The niece is on the till. uncle baking bread, aunties making soup. The profit just doesn't go into one pocket. It pays the marae bills, feeds manuhiri at Tangihana, and keeps our tamariki in uniforms. But under this bill, her way of running that cafe on marae or whenua Māori, in line with tikanga as a collective, could suddenly be called inconsistent or too restrictive or not good business. How is that fair? And then you've got our big Māori land trusts out at the orchards. They're planting, harvesting, and protecting the ngāhere all at the same time because they're kaitiaki of that whenua. But the bill wants everything measured in individual property rights and lowest regulation. They're not just thinking about the profit, they're thinking about mokopuna, the awa, the birds. But this bill doesn't value that. It would let anyone challenge them because they don't fit the mould. And if we don't speak up now, what's next? The reo on the walls, the karakia before the hui, the way we share kai, they'll even say that's inconsistent. So that's our auntie, and that's how she's telling it. And that's what we're worried about. We want better regulation too, of course, but we need rules that fit us, not rules that force us to stop from being who we are. So our recommendations are this, and on behalf of our members, we ask the committee to reject the bill in its current form and to refocus efforts on moving forward in the spirit of Te Tiriti o Waitangi in genuine partnership with iwi Māori. This includes engaging and meaningfully consulting with Māori in good faith at all stages of regulatory reform, governing Aotearoa in true partnership with Māori as Te Tiriti partners, investing in initiatives to improve outcomes for Māori and to reconnect Māori with their reo, tikanga, marae and whenua in order to right the wrongs of the past. We cannot stress enough the good faith engagement with Māori is not merely a procedural requirement. It's a moral obligation that the Crown must honour. Genuine engagement involves building relationships founded on respect, transparency and shared decision-making. So in closing, despite the real economic benefits of Pākehā Māori contribution of the 126 billion and climbing to Aotearoa's GDP, in spite of any current regulatory standards bill, they're not just businesses. They're expressions of tino rangatiratanga, vehicles for intergenerational well-being, and anchors of culture and connection. On behalf of our members, I urge you to reflect carefully. We want better regulations too, but not regulation that comes at the cost of our identity, our rights, and our futures. Ngā mihi nui ki a koutou katoa.
Kia ora. Thank you, Jackie. We're at time, but I'm going to give one of our aunties on our committee, who sometimes she knows how to cut through complicated issues with short words as well sometimes, our dear colleague, Dr. Deborah Russell.
Thank you, Mr. Chair. Kia ora, Jackie. That was a fantastic submission. Thank you. Look, the bill and the people who support it, they promote a standard of formal equality. And I think the answer they would say to you about with your auntie's story, they'd come back and say, but yes, but you are equal. This is treating everyone equally. So it's a very formal notion of equality. Do you see a difference between that formal notion of equality and a substantive notion of equality?
Yes, because, well, if you look at, for example, freedom of contract, and that means that individuals and businesses should be free to make arrangements on their own terms without unnecessary interference of law or regulation, as long as both parties agree. However, as mentioned, Māori land and assets are often held collectively by trusts and corporations and maraes. So you can't just have one person who's freely contracting to sell land or resources or even commercialise or profit off land and resources. It requires a collective consent and consideration of tikanga, whakapapa and long-term stewardship. And that's what would be missing from that formal, equity process. That equity isn't there because it's not recognised that tikanga would be part of that process.
Okay, Kapai, thank you for that.
Okay, thank you, Dr. Russell, and thank you, Jackie. We will leave it at that. Keep up the good work, Jackie, with your association, and we look forward to another interaction another day. Enjoy the rest of the day. Thank you. Okay, that takes us to our final submitter, the PSA Runanga. Who have we got lined up there, Madam Clerk?
Kia ora koutou. Can
Joanna
you hear me?
Houston. Oh, very
Joanna.
good.
Kia
Oh, well,
ora.
yep, this is by design, not accident. Thank you for your patience. We've left the best to last. So we're in your hands, and allow us a little bit of time at the end if you can.
Kia ora. Tēnā koutou. He uri ahau no ngā te kahununu ki te wairoa tūwhare tō me Nati Ruanui hoki, ko Joanna Houston tōku ingoa. I am the Vice President Māori of the Public Services Association Te Pūkenga Here Tikanga Mahi, commonly known as the PSA, Trade Union for the Public and Community Services. I am also the tuakana for Te Runanga o ngā Toa representing our Runanga membership of the Public Services Association. I'm also supported here today by our President, Virgil Iraia. Tēnei te mihi kia koutou katoa. Firstly, I just want to say thank you for hearing our submission, and I also want to acknowledge the many voices that I'm representing as part of delivering our submission to you all. The PSA isn't only the largest trade union in Aotearoa, but with more than 95,000 members, we are technically the largest trade union in all of Australasia. We have 95,000 members from across 5 different public service sectors, from local government, health, state services, community services, and the public service sector. And that means something to us, and it means something to the communities that we deliver services to. We are the people's workforce, and we are the public's workforce. On behalf of Te Runanga, o ngā toāwhina, our Māori membership stands in solidarity with every other submission that has opposed this bill. Now, I'm not a politician, I'm not a legal expert, I'm not an economist. Okay, I have no idea about the long-term implications this bill will have on our economy, and I have no idea what it takes to understand what defines good lawmaking. I'll leave that to the likes of Sir Geoffrey Palmer, Tania Waikato, Professor Jane Kelsey, and whoever else has the calibre to be able to debate those kind of talking points. My job as Vice President Māori and as the elected tuakana is to know and understand the employment realities of my membership, and more importantly, to carry the voice of our 11,000 Runanga members at the PSA into spaces where they themselves cannot be. And that's why I'm here today. Te Runanga o ngā toāwhina not only opposes this bill, but we reject the deception in which it has been presented, and we reject it because of everything that has been unilaterally decided as being a benefit or a not so benefit in terms of its drafting. Morally, constitutionally, legally, ethically, whatever the case may be, we just haven't been engaged. Our recommendations to this committee are that the bill not progress. We do not support this bill in its current form, nor will we support the bill in any future variation of it. We recommend that the Select Committee recommend to the Government to accept the findings from the Waitangi Tribunal's 2024 report Ngā Mātāpono. We recommend that the Select Committee recommends the Government accept the findings of this report, and that the Government formally recognises tino rangatiratanga of Māori and the Crown's agreement with Māori to kawanatanga as laid out in the Māori text of Te Tiriti o Waitangi. The bill represents a significant and dangerous precedence for the constitutional landscape of Aotearoa, New Zealand, with serious implications for the treaty partnership between Māori and the Crown. This bill will take Māori-Crown relationships backwards. And as our elected government officials, you have a responsibility to ensure that does not happen. Te Runanga has identified that if it does, our members will look to hold this committee accountable for it. We are strong in our solidarity with everyone else who opposes this bill, and we are strong in the reasons and why we are opposing it ourselves. We encourage the committee to consider our submission, our written submission, in earnest and understand the importance and the significance that we have delivered it in. Tēnā tātou katoa.
Oh, thank you very much, Joanna. Well articulated. Have we got any members that have got any questions or comments?
It's been a long day. We've heard lots, but that's not to say that yours was not a great submission. I just do want to recognise that and recognise that you've put a lot of work into it, and it's an important contribution. So thank you.
Kia ora. Thank you for the kōrero and for your whakaaro. It's appreciated.
Yeah, thank you for that, Dr. Webb, and again, thank you, Ms. Houston, for your time and energy late this afternoon. Members, that concludes the hearings for the Regulatory Standards Bill. Thank you, members, and the Clerk's Office in particular for all your organisation. It has run as smoothly as we could have hoped for. Thank you, members, for your consideration, your cooperation and your contributions. Enjoy what's left of recess, and we will see you back in Parliament. Thank you so much.
Ka kite, everyone.
Thank you.